1 o'clock. My lord, at the moment I am seeking leave, my lord, to dispense with the e-filing so that, my lord, I can get the plaint affirmed, my lord, and move it at 1 o'clock, my lord. This is in respect of a bank guarantee. We have been served yesterday. Overnight, we have got the plaint ready. My lord, very strategically timed because it's a Friday, Thursday night, my lord, we get the letter. We have prepared it overnight, my lord, to move it, my lord. In respect of a contract which has been completion certificate given, defect liability period over, my lord, invoked it after 2 years.
Gun. 1B. So fix है 3B फिक्स है. ठीक है, एक सप्लीमेंट्री लिस्ट दो 3 PM के बाद 3:45
Endorsement
3:45
345. Obliged.
May I be permitted to mention a matter? Your Lordship had passed an order on the 9th of May 2024 in this matter. Lordship, this is relating to operation of the trust property and 2 receivers were appointed. It was appointed on consent. Your Lordship, the bank account is not being operated because the bank is not acting as per such order. Lordship, may the matter be listed on any day. I have given notice to my other side. My other side is also present. Lordship, only for a direction that the bank account be allowed to be operated by the incoming receivers and deletion of the name of the erstwhile receiver.
Who is for the other side?
Lordship, my learned friend is...
number 9.
Yes. Discharge as a receiver and division. Wednesday is to be mentioned.
I'm grateful, Your Lordship.
My lord, may I have my lord's kind leave? This matter has been assigned to my lord. So, my lord, I was just beseeching if my lord may kindly fix it for under the heading to be mentioned. So that the witness action was going on. So, any day, my lord, convenient.
Witness action assigned.
Yes, my lord, because my lord, this matter has been heard by my lord for 35 dates. So thereafter, we got it released.
That one.
Yes. So any day to be mentioned so that the date can be fixed for further witness action.
The commercial, non-commercial, non-commercial,
Non-commercial.
non-commercial.
I have served my learned friend.
Thursday is to be mentioned. Wednesday, other matters. Okay.
May I have your Lordship's leave to mention a suit, my lord? My lord, this is a suit which is appearing in your Lordship's list, my lord, but the defendants have not entered appearance in this suit, my lord. There have been previous orders by which substituted service was directed to be effected upon the defendants, but despite that, my lord, they are not appearing. My lord, there is a report also from the department which states to the effect that the defendants have never entered appearance in the suit. And my lord, when the suit last appeared before your Lordship on the 6th of May 2024, my lord had directed my lord the plaintiff to obtain a report to that effect from the department. So, my lord, I was humbly beseeching your Lordship, my lord, to kindly fix the suit as undefended suits, my lord. There are another 2 connected suits.
So it is listed or not?
Yes, my lord, it is listed. My lord, it is appearing under the heading of hearing.
It is a non-commercial.
It's a commercial suit, my lord. It's a commercial suit, my lord. I have indicated the other
Item
2.
number?
My lord, the item numbers, my lord, I'll have to check up. But, my lord, it is appearing under the heading of hearing.
Hearing.
Yes, my lord. There are 3 connected suits, my lord. The defendant is a common defendant. And, my lord, in all the 3 suits, my lord, the defendant...
You check the list which in which serial number the matter is listed.
44.
Hearing is only one matter today.
My lord, it is appearing in your Lordship's list, my lord. I had checked up and...
Maybe in the monthly list.
No, my lord. It is appearing in the daily list, my lord. It was appearing on Tuesday, my lord.
And commercial division. मनु तो कल जजमेंट का कितना एक मैटर उठा नहीं है.
My lord, it is appearing as item number 102, 3 and 4, my lord. 101, 2 and 3.
ये तो सब IPD और एक CS com.
My lord, there are 3 connected suits, my lord.
Item number
My lord, item numbers 101, 2, and 3.
1, 2, and 3.
Yes, my lord.
Yes.
My lord, in all these three suits, my lord, the defendant has not entered appearance.
In all the suits, you have obtained
Yes,
the
ma'am.
report.
Yes, my lord, I have obtained the report, my lord. But I am carrying only the report with effect to only
All
one suit,
report
my
on
lord.
Tuesday. Tuesday to be mentioned, all 3 matters.
I'm grateful, my lord.
My lord, may I have my lord's leave, my lord, to mention 4 commercial suits.
Hmm.
My lord, right now, my lord, the witness is being examined on commission.
Hmm.
The time to complete commission is expiring on 6th.
Hmm.
My lord, that is why, my lord, I am mentioning, my lord.
For the other side.
My lord, we'll give notice, my lord. Yesterday, the commission happened, my lord. We had intimated.
When the next date is fixed.
My lord, the next date is fixed on 8th, but the time is expiring on 6th.
6.
6th is Tuesday, my lord.
Okay, let it on Monday as to be mentioned.
Extremely
From
grateful.
the other side.
Yes, my lord, I shall inform. Extremely grateful.
Lord,
Madam, may I be permitted to mention item number 19 of regular list today? Madam, we are just out of time to file the reply.
19.
Item number 19.
New motion.
Under original side daily list, Devjyoti Banerjee for
Huh?
filing adjourned motion.
Non-commercial matter. Yes.
Madam, may I be permitted to file the reply? We are out of time to file the reply.
Only reply. Let the matter come on that you serve the
Madam,
copy.
it is not being called out and the other side is not receiving it because.
Okay, when the matter call, you come with the reply. You already affirmed the reply. No? Okay, you come. When the matter is called, you come. Yes.
Lordship, may I be permitted to mention these are 3 IPAB matters, Lordship. It was being heard, but then it has not gotten an opportunity. I understand my Lord's list has been overburdened, but kindly, if it can be fixed as
But
to be
what you're
mentioned.
telling, heard?
It was heard with before the previous bench. It was not heard before this bench. I had mentioned it before, but my lordship list was overburdened. If it can be under the heading of to be mentioned on any day, we can fix dates for these matters, lordship.
Who is for the other side?
I am upon mentioning
You
upon.
are for the respondent.
I am for the petitioner and appellant in all the matters, lordship. I have it. I'm mentioning upon notice, and if my lord keeps it as to be mentioned, I'll serve another notice, lordship.
Tuesday has to be mentioned.
Tuesday has to be mentioned. Grateful, lordship.
Your Lordship, I'm seeking your leave to mention one matter. Your Lordship, I'm mentioning item number 35 and 36 of the list. Your Lordship, the counsel for the petitioner, Mr. Suresh Sahani, is an outside counsel. I'm praying that the matter be fixed any day next week, Your Lordship.
35?
35 and 36, Your Lordship.
Okay, when the matter call, you mention the receipt.
Lordship, kindly may I mention item 1 of the non-commercial list, Your Lordship. Lordship, I'm seeking only a procedural direction for substituted service in this matter, Your Lordship.
Non-commercial list.
Non-commercial.
Commercial day.
Lordship, since only procedural direction is to be sought, Your Lordship, for substituted service.
Item number 1.
Item number 1, Your Lordship, to be mentioned.
Protomac.
Lordship.
Yes. What direction you?
Lordship, substituted service, Lordship. I have a report, Your Lordship, that the writ of summons could not be served upon the defendant, Your Lordship.
Come on Wednesday. That will be written as it is. Come on
Lordship.
Wednesday.
Grateful, Lordship.
Yes, and commercial list for judgment item number 1.
The order is set aside. Matter is remanded for reconsideration by some other officer at the stage of the argument. Within 6 months, it is to be dismissed.
Great.
Item number 2, 3, and 4.
Yes, Your Lordship.
By a single
Yes,
order, hold off. The order has been set aside. It has held the associate manager is not the authority. Pass appropriate order by the competent authority. Yes.
No, Your Lordship, I was appearing for petitioner in item 2 and 3.
Yes. Next.
Wait, please, my lord. I'm appearing for the petitioner. Lord, this matter, my lord, cancellation of trademark, my lord, this is coming like this was.
Huh?
My lord, this cancellation of trademark, my lord. My lord, this matter was dismissed for default. My lord, thereafter we had filed a recalling application and a restoration application. That application, the affidavits of that applications are complete, my lord. Lord, at the end it is ready for hearing, my lord. My lord can fix any date for.
Who has mentioned?
Yes, but we have mentioned the matter and
For hearing of the
for listing for the purpose of hearing.
Who is for the other side?
Mr. A. N. Bhattacharya is appearing for the other side, my lord.
GA Com 1. What is your application number?
My lord, GA Com 1 of 2024, IPD ATM 6 of 2022.
No, restoration application is GA Com 1.
Yes, my lord.
So bulky for recalling.
Yes, my lord.
Have you served the copy?
Yes, my lord. Already served, my lord.
Who's appearing?
Affidavits of
Have you issued the notice of the mentioning?
Yes, my lord.
No.
Lord, it was served, my lord. We are not ready with the notices now. Let it be fixed on any other.
You are appearing?
Yes, yes.
So what is your submission? Recall application can be allowed.
Your Lordship, I need some time, Your Lordship. I am led by Mr. Auritra Basu in this matter.
Have you filed the
Yes.
opposition? Have you filed the opposition? They filed the affidavit?
Yes, my lord. Opposition has been filed, my lord. Our reply, we are ready with a reply. It has already
Opposition
been
is not on
served.
record.
My lord, they are filing it here. It was served, my lord. We had prepared our affidavit and reply. May I have your lordship leave to file the affidavit of service also, my lord, in that case.
The matter is listed as to be mentioned on behalf of the petitioner. The petitioner has filed an application being GA Com 1 of 2024 for recalling of the order dated 3rd April 2023, wherein this court has dismissed the petition for default. Counsel for the respondent has filed affidavit in opposition, and the counsel for the petition has also filed the reply. Counsel for the petition also filed the affidavit of service. Let the same be kept in the record. As the pleadings in respect of GA1 Com of 2024 is completed, please the matter.
My lord.
On 20 August under the heading adjourn motion.
Grateful.
Next.
Only for the recalling application.
Recalling.
There is another application, item number 9. Among the
rectification petition filed by us, that is the respondent, my lord, asking for rectification of the mark, my lord, the registration of the mark.
So that is to be heard along with the merit of the matter of the first matter. No.
More or less interrelated.
That's why.
My lord, one, I tell your lordship, my lord, they have filed an application for rectification against our application of the label mark.
Okay.
That is the Calcutta Times channel, which your lordship knows. Now, my lord, we have filed a rectification against them for rectification of the mark time, because cannot have a right on the word time. Both of them, my lord, are interrelated with a suit which is going on before the Delhi High. There is no order of an injunction. The main crux of the matter is basically with regard to the get-up. That is blue, red, and white get-up.
Yes.
And that is the main.
If I may say, my lord, both the matters are with regard to separate marks altogether, my lord.
Yes, yes.
It's not the same mark
One is
with.
the word and the other is
why 6 is mentioned?
My lord.
5 and 9.
5 and 9.
Yes.
5 and 9, my lord. Yes.
So why 9 is mentioned?
For the very purpose, my lord, it has not been taken up as of now, my lord.
Well, 9, there is no recalling.
There is no recalling.
No recalling.
Yes.
So 9 is to be fixed for hearing.
Yes, my lord.
Affidavits complete.
No, my lord. No, it's coming up for the first time.
Matter transferred from the IPAB.
After the abolition.
So perhaps, my lord, affidavits would not be required.
Have you enclosed all the documents? Who has filed? Who is the petitioner?
But in the rectification, my lord,
you are the petitioner.
My lord, may I say, my lord, since it is a transferred application, my lord, we need to peruse the original records, my lord, to tally it with
okay, let the matter be called. I will see what other document is there.
Much obliged, my lord.
Grateful.
Hey.
My lord, I'm appearing on behalf of item 6, my lord, I'm appearing on behalf of appellant. I think in this matter, what happened?
Yes.
why it is appearing, I do not know. But in this matter, what happened in the appeal cause paper the department had given the three appeal. Subject is the same. So my lord, by order dated 2nd February and 27th March, my lord directed the two appeal has to be infructuous. It should be disposed of, and APAT number 45/2023 should be proceeded, my lord. This is the two orders. One is in respect of the 79 that the treated had infructuous because the earlier AP number, IAP number 59 is already given. Thereafter, the 59 has also been disposed of.
Oh, 6. The appeal has been registered wrongly. IPDPTA 79/20. There is a prior appeal of 59 or 2020.
Yes,
so 79 is dismissed.
This will thereafter subsequently appear that they have given another number.
Just a minute. No, it was Thank you. Yes.
The 79 is dismissed as an infructuous, my lord. Thereafter, again, the 59 appear, it transpired from the record that another number 45 has been given. Accordingly, the 59 has also been disposed of. Directed all the records should be merged with the IPD 45. I am directing, my lord, whatever record is there, my lord, kindly that has to be merged with the IPDA number 45. Because there 45 is the main number.
So now 79 is over, 59 is over, now 55.
Only 45 is pending.
45 is pending.
So
and
whatever record is there, that
per,
should be merged
as per
with
the order dated 27th of March, this court has directed that to merge the record of this proceeding with
the
45.
IPDA 45.
59 and 45 has been merged.
59 and 79 has been disposed of as an infructuous.
But kindly see the order. Which
yeah, in this order, my director of whatever record in 59, that should be merged with 45.
Yeah, that's
yes. So all the records, whatever in 79 and 59, that should be merged with 45.
So appearing for the petitioner. Full stop. Counsel for the petitioner submit that in the department it is found that there are two appeals record of 2 appeals were lying, being IPDPTA 79 of 2023 and IPDPTA 59 of 2020. Subsequently, it was also found that another appeal being IPDPTA 45 of 2023 is also pending again the same order. Accordingly, by an order dated 2nd February 2023, this court has dismissed IPDPTA 79 of 2023 as infructuous. And by an order dated 27th of March 2023, this court, March 2023, this court also dismissed IPDPTA 59 of 2023 as infructuous. And it was directed that the appellant shall proceed with IPDPTA 45 of 2023. And it is also directed the department to merge the record of IPDPTA 59 of 2023 along with the proceeding of IPDPTA 45 2023. In view of the above circumstances, the department is directed to place the record of IPDPTA 45 2023 along with the record of IPDPTA 59 2023 before this.
And 79 2023 also.
79 has not.
45
I think, as well as 17.
Yes, Malab, because some record may be lying there, Malab. I don't.
79 of 2023.
That
list the matter on 27th of August
27th
August.
So this is my appeal.
I am for the respondent.
Lordship, this appeal was filed, Your Lordship, along with Your Lordship, the prayer for condonation of delay but the department, your lordship, has taken, your lordship, an objection that there has to be a separate application. So I filed a separate application
For delay.
for delay.
For the respondents, my lord.
I will serve.
For the respondents.
Lordship, the impugned order, your lordship,
Opposing, my lord, because they admittedly they have delay of 375 days, my lord.
there was a review application.
Yes, my lord.
And the review application.
And according to me, my lord, there are two orders. From first order, there are more than 602 days delay, and from the second order, 527 days.
500.
But there are, your lordship,
delay,
in the
madam?
meantime, your lordship, the Supreme Court's judgment was there.
I have counted that.
The
madam.
entire,
I have counted that.
entirety, your lordship, has to be excluded.
Okay, whatever it is, they wanted
I
to
have
file the
counted that.
So you want to file affidavit or hearing? Yes, Mr. Singhania, Mr. You
Yes,
filed
my lord.
affidavit?
They will file a opposition, my lord. There is a mistake in calculation. 2 years plus
They
90 days.
always take time, but they don't file the opposition. At least, your lordship, let them file the opposition.
There is a mistake in calculation.
Concessions appearing for the appellant, concessions appearing for the respondent. Full stop. The appellant has filed an application being GA-1 of 2024 for condoning the delay of 300.
Lordship, 300 and
75 days, according to them.
The delay of 300 and odd days. And odd days. Full stop. Counsel for the respondents prays for time to file affidavit of
375
opposition in connection with GA-1 of 2020. Let affidavit of opposition file
3
within
weeks, 3 weeks.
3 weeks. A reply, if any, within a week thereafter. List the matter on 9th of September 2020.
Lordship, only the affidavit of service, your lordship.
Affidavit of service filed by the appellant be kept with the
And I filed this application, your lordship, with the leave, your lordship, to produce the copy of the power of attorney, your lordship, that came, your lordship, out from outside.
Keep
with
it
an
on the,
abstract.
at the time of hearing of the marriage.
Lordship.
Here will I am for the respondent 2, my lord, here in this case.
My lord, I am for the petitioner, my lord. Is my rectification application, my lord. My lord, previously this matter appeared in 2023 for the first time after being transferred from the Intellectual Property Appellate Board, my lord.
Yes, who is for the authority?
I am appealing for the respondent 2, my lord.
Yes.
My lord, respondent number 2 have served notice. My lord, I am told that
whether-
he is on the way.
Whether the records have been transmitted by the department, you are Mr. Singhani, you are appearing for the
Yes.
registrar.
So for respondent 2, my lord, here.
Who
Control.
is the respondent number 2? Who is
Control
the
of
number 2?
My lord,
trademark authority.
my lord, respondent number 2 is my lord, Berger Paints, my lord.
Berger Paint is the
No,
number,
no.
I think.
My lord, sorry, respond number 1, my lord. I'm sorry, but respond number 1 is Berger Paints and respond number 2 is the registrar of trademark, my lord.
Yes. So I am for the respondent 2, my lord, here. For the registrar of trademarks.
So you have to transmit, your office is to transmit the original record. There's an order.
Then, my lord, I have to ask them, my lord. If original records has to come, then I will ask them too.
Yes, of the patent number.
Well, this is a trademark application in respect of a trademark application.
Yes, yes.
ए मनोज रिकॉर्ड आ गया क्या? नहीं है, खाली अपील आया. Where is your appeal?
Well, this is not an appeal. This is an original rectification proceeding.
Where is your application?
My lord,
Rectification application.
I've got copy, my lord. Those are all transferred documents from IPAB, my lord.
Application for removal of trade.
My lord, my lord.
That is, na?
Yes.
Where is the original? Why office is not submitting report? So what record is required further?
No record is required. This is self.
This on the basis of
yes, on the basis of this appeal, we can proceed with, my lord.
So, Mr.
Yes,
Records
yes,
are not required.
Who is for the respondent number 1?
My lord, Mr.
Berger
Kavach
Paint?
Kashyap was appearing, my lord. But
So why you have mentioned?
Malad, I mentioned for hearing of this application, my lord, so that it can be disposed of. It's
Whether they will
pending
file
since long, my lord.
Whether they will file affidavit or not,
My lord.
nobody is there.
My lord, lordship kindly pass it over, my lord.
Pass over.
I am appearing for the petition of the
I am appearing petition.
No, no, এটা তো উল্টো হলো।
Yes. This is the ratification application.
Yes, both are this is R against you.
You are
Lord,
for the
if
petitioner.
it's coming up for the first time, Lord. Lord, we would need to tally the records, original records with
Inspection.
our Lord. If it is allowed, if such liberty is given, my Lord, we can check it here and now, my Lord. But what has happened, my Lord?
Who is for the respondent?
I am appearing for the respondent.
One. Respondent number one.
Lordship.
Mr. Singhania, you are appearing for respondent number two.
রেকর্ড দেখলে বুঝবে আমিও মানে একটু অসুবিধা হচ্ছে এটাতেই
So appearing for the
I was
petition.
appearing in 8 minutes, sorry.
9, you are not appearing.
No, I'm sorry.
Have
I'm
you
not
saw
in
the
the
copy?
My lord,
Have you saw the copy to the respondent
I
number?
must tell your lordship, I'll be very candid to your lordship, my lord. In both the matters, that is 5 and 9, we were appearing all through. Thereafter, there were certain miscommunications or somewhere without any NOC or anything. Someone was told to appear who had appeared on in item number 5. That's what this miscommunication. Now, all the documents were returned by us for some reasons or the other. Now, the thing is that we don't have any records. Now, just one thing, my lord, I have the documents of 5. Now, for 9, I also don't have any papers. I don't know whether any counter was filed to the main petition.
There's nothing. Only the petition is there.
So we'll have to file.
Okay, okay, I am recording his submission. Let him inspect the record and direct the serve the notice to the other side further if they will.
Your lordship is both the parties to inspect the records.
Yes, my Lord. On the joint prayer, we can.
So appearing for the petitioner. Can your name be recorded?
Yes.
So appearing for the respondent. Full list of counsel for the respective parties prays for leave to inspect the record of the instant matter. Full list of leave is granted. The advocate on record of the parties are given liberty to inspect the record within a week from date. Let the matter appear on 27th of August 2020.
My Lord, one the other matter is appearing on 28th, as the Lord said. Let it be
28, I don't think.
20th, my Lord.
20. Okay, 20th. 2020.
I'm grateful, my Lord.
Both are on 20th of May.
20th, yes.
Just give me one.
Next.
20th of May.
20 August.
Okay. Well, it may be on the 23rd.
Yes, 23rd. Both matters.
Grateful.
5 and 9, 23rd. Yes.
Lordship, I'm for the plaintiff in item number 10. On the earlier occasion, your Lordship was pleased to forfeit the right to file the written statements for the defendant on July 5, 2024.
You are for the?
I'm for the plaintiff.
Correct.
Now we have further, for abundant precaution, we have obtained a certificate on 19th July that still no written statement has been filed, and in anyway 120 days have passed. May I only pray that this suit may appear as an undefended suit, and thereafter the Lordship fixes time for hearing of this.
Only sole defendant?
Sole defendant.
Whether they have preferred an appeal against this order, 5th July order?
Lordship, no. We have not taken explicit instruction, but
yes,
nothing has been served upon us.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Full stop. By an order dated 5th of July 2024, this court has dismissed the application filed by the defendant being GA-Com 1 of 2024, wherein the defendant has prayed for extension of time to file written statement. Full stop. The plaintiff has also obtained report from the service report from the department, wherein it is found that the writ of summons was duly served upon the defendant, and it is also found that though the defendant have entered appearance but have not filed written statement, let the report be kept with the report. In view of the above, list the matter. In view of the above, list the matter in as in undefended suit. Full stop. The plaintiff is directed to file the judge's brief or document within 2 weeks.
Lordship, within 10 days, we will file.
Within 2 weeks. Full stop. The counsel for the petition is also directed to file the affidavit of evidence of the plaintiff within a week thereafter.
Lordship.
Full stop. This is the matter on Manutosh. 1 बजे का टाइम है कोई विटनेस एक्शन के लिए लास्ट वीक ऑफ सितंबर अगस्त और सितंबर फर्स्ट वीक कब है 1 हाँ how much time will take?
Lordship, not much.
Not much. Half an hour is enough.
Lordship, more than
19? No, lamba. 29th August. That is Thursday. 30 August at 1 p.m. for witness X.
Lordship, Lordship, may it be kept some other day. My advocate on record will not be available on 30th.
Then 3rd September?
3rd September.
2nd September at 1
2nd
p.m.
September. I'm grateful.
IPA for the defendant number 2.
11 and 12 are two suits against the same between the same parties, but in respect of two different contracts. That's why there are two suits. Otherwise, they're absolutely identical in every manner. There are 3 pending applications in these suits. If I may just indicate what these applications are. In both the suits, the identical applications. GA number 2 has been filed by the defendants for revocation of section 12A of the Commercial Court Act. That is GA number 2. GA number 3 has also been filed by the defendants, saying that in case GA number 2 is disallowed, then allow me to file my written statement. Although the period has gone. And GA number 4 is my application for urgent. I am the plaintiff, my application for urgent reliefs. So any day that suits the benches. It was being heard. They were being heard. One of the casualties of change of determination. So we were requesting.
If it is heard extensively, then I will release.
No, it's not heard extensively, your lordship will kindly give any
affidavits completed.
Yes, affidavits are all complete except from GA in GA 4 rejoinder has not been filed in GA number 2 and 4.
Rejoinder is to be filed by the defendant. 4 is your application.
4 is my application. I have to file that.
And what about 2?
It's a formal
reply you not filed.
No, that is my application. They have filed the opposition reply.
I'm sorry, GA2, it's only in 4 it's outstanding. In the others, it has been filed. I'm sorry. Only in 4 it is outstanding.
So
reply.
Appearing for the plaintiff, so appearing for the defendant. It is submitted by the learned counsel for the respective parties. There are 3 interlocutory applications being GA2 of 2023, GA3 of 2023, and GA4 of 2023 is pending. And in all the applications, pleadings have been completed and dates for fixing the matter for hearing. Considering the submission made by the counsel for the respective parties, list the matter on, give the one date, give 2 dates, 2 dates. 2 dates so that the consequent date.
Yes, I'll be very grateful.
All the applications may be taken up together.
That's why.
Yes,
all the application.
One set of argument in all the applications.
my lord, I have perhaps not filed, my lord, in GA2, my lord, I have checked.
Yes, my lord, maybe GA2 and 4, my lord.
If
The
it's
lordship
not
will-
filed, you
Lordship
bring
will
on only
direct-
the reply is required.
Yes,
No, you
reply,
come
only
bring on
reply.
that.
Yes.
The lordship will direct that all affidavits to be completed by then.
17 and 18 September at 2 p.m.
I'm grateful.
17th and 18th September 2 p.m.
I'm so
Grateful.
grateful. Deeply blessed.
Item number 13. That this was in your lordship's list on 26th of July when your lordship had adjourned this matter to 31st of August. But I'm sorry, 30th of August. But that is why we had mentioned the matter, so that the matter may remain in the list, that lordship may not fix any time.
No, 30th August.
30th, there's some urgency in the matter.
Who is for the other side?
But we seek to move it ex parte. That is why 26th of July could not be moved.
No. As per the prayer made by the counsel for the plaintiff, case adjourn, let the matter appear on 30th.
But I'll tell you, Lordship, I've been told a password was sought for, but it could not be explained to your Lordship. That is why Lordship adjourned this matter to 30th of August. Lordship will kindly keep this matter in the list. Let it remain in any position. New motion, as new motion.
So the matter is listed as to be mentioned, na? To be mentioned on the prayer made by the counsel for the petitioner, plaintiff or petitioner.
Plaintiff petitioner.
Counsel for the plaintiff submitted, though the matter was listed on 26th of July 2024, but this court has fixed the matter on 30th of August 2024. Counsel for the plaintiff submitted there is an urgency to move the application and wait for advancement of the date of hearing. In view of the submission made by the counsel for the plaintiff, let the matter appear on
next week, any day, on Monday, Tuesday, let it be there in the list as new motion.
On 9th of August. 9th of
August. Okay. Grateful.
Under the new motion.
Right. Great.
Next.
If it pleases your lordship, this is my suit for infringement and passing off.
Yes.
Contemplating urgent interim reliefs, your lordship. Your lordship, I'm praying for 3 leaves, your lordship. Clause 12, section 12A, and order to rule 2. Your lordship, clause 12, the necessary pleading is at paragraph 73 at page 50. I am the owner of the mark, your lordship, and the defendant is the ex-license.
Paragraph?
Paragraph 73 at page 50. That is the pleading regarding clause 12. Cause of action has arisen both within and outside, your lordship. I am within, your lordship. We've already served cease and desist notice. They've already replied. They're not willing to listen, your lordship.
When you issue the cease notice?
Yes, your lordship would find the pleading at paragraph 75. Your lordship, the cease and desist notice has been issued on in May. I'll just indicate the date, your lordship.
In June.
Yes, your lordship. They have replied, and we have also replied to their reply.
Yes.
And I'm also praying for leave under order to rule, Your Lordship.
Counsel is offering for the plaintiff. Plaintiff has filed the suit for perpetual injunction and other reliefs. Full stop. It is found that the plaintiffs are within the jurisdiction of this court and the defendants are outside the jurisdiction of this court. Now, defendant number 1, 2 are outside and the defendant number 3 and 4 are within the jurisdiction of this court. Full stop. The plaintiff has also issued the notice, ceased and desist notice upon the defendants. Cease and desist notice. CES here, cease and desist notice upon the defendant. But in spite of the receipt of the notice, the defendants are not stopped for selling the items under the mark JJ Deluxe. Full stop. Consider the submission made by the counsel for the plaintiff for use the materials on record. Leave under clause 12. The plaintiff has also prayed for urgent relief. Consider the submission made by the counsel for the plaintiff for use the materials on record and the amendments made in the print. This court grant leave under clause 12 of the letters patent of 1865, leave under order 2 rule 2 of the CPC, and leave under section 12A of the Commercial Code Act. Plaintiff is admitted, subject to scrutiny by the department. The plaintiff has also filed an application for urgent relief. Let the matter appear on Monday.
Your Lordship, yesterday Mr. Ghosh had mentioned that there is an urgency, so the injunction application is appearing, Your Lordship. Mr. Basawat is leading it. May Your Lordship kindly permit the injunction application to be moved today.
Yes.
But it relates to a product which has, I thought had gone out of fashion. Lord, these fuses. I thought that nowadays it's all those MCBs, but it's a big item. Now, it relates to this, and the fight is between the owner of the trademark and his erstwhile licensee. But licensee is now making the same thing. If your Lordship has a look, just compares the packet ones. Yes. But they come in various sizes. I have packets of different sizes here. The one on top is mine, the smaller packet. And
this is yours.
Yes. And your Lordship will find on top it says unit of JJRS Enterprise. Now on my packet also your Lordship will find something. But if your Lordship looks at the side, your Lordship will find manufactured by and marketed by. Your Lordship has found manufactured by Mahavir.
Manufactured.
Not on this side. Not a white colored label. Your Lordship has found a white label on the side.
Manufactured by
Mahavir. Manufactured by Mahavir, who is the defendant. And please see, marketed by JJRS. So, this was my mark. He was manufacturing for me, and this was sold in the market and identified by a unit of JJRS on front. Now, please see his. Now, there's a checkered history which I'll come to in a moment, but this is not the meat of the matter. Now, again, please look at that unit of JJRS is gone now, from the front, and at the side, your Lordship will find marketed by is also gone. It only says manufactured by Mahavir. Now, this is the packets are identical, your Lordship has seen. The trademark is identical.
So this one is a defendant.
Yes, yes.
Yes.
Not they are otherwise identical. Now, I'll give you a Lordship. There's a little checkered history here. Now, my Lord, from 1978, these marks have been there, owned in the family. In the family, there have been divisions from time to time. That's not the subject matter of dispute. Not ultimately, my father, not the plaintiff's father, and two of the defendants here, being the defendant numbers 3 and 4. come to be the co-owners of this mark. Other branches of the family have not related marks for related or different products. It was also not registered in the names of not all three brothers. Not this was the given situation, it was carrying on. Now, somewhere down the line, Millard, this defendant, not he applied for and got registration of the marks in his own name. So, Millard, a suit was filed and a decree is passed. I'll take your lordship into that. Consent decree is passed. It says he acknowledges us as the absolute owner of the marks. He has no right. He will not do this. He will take steps for withdrawal of the registration applications, etc. And it says that I will get the goods manufactured by him. That's the decree. I'll take your lordship into it in one moment. I'm just giving your lordship the background. So, this happens in 2014. Thereafter, the plaintiff's father dies. After that, they are inducted in the firm. Two brothers, they are inducted in the two sons rather, are inducted into that partnership. Then some disputes break out. We leave. Both branches carry on under similar associated trademarks. We call as JJ Deluxe. They call theirs. What was it? JJ Champion and other things. So, two branches of the family carry on. No one is objecting to anyone else's user of the mark. This has happened in 2019. We carry on. Now, when we separate, under the decree, he was to manufacture for the firm. So now, he enters into independent agreements with our branch and their branch. Under that agreement, he acknowledges I am the owner. Obviously, he has to. He will manufacture on our behalf and as the usual thing under supervision, control, etc. So he does it. And that's why, the boxes bear my name and his name. Your lordship has seen that. Now, suddenly, we discover that he has filed a new trademark application for this same thing, this JJ Deluxe. So when we find it, we start looking into the registry papers, and it turns out that defendant numbers 3 and 4, who are only co-owners, please remember this, they are co-owners, they can't deal with the mark independently, number one. Number two, please remember, he is my licensee. A licensee can never challenge my title. Now, they enter into something they call a coexistence agreement with the defendant numbers 1 and 2. This coexistence agreement, I'll show your lordship, it's meaningless, but it says strange things, including saying that the decree in the Delhi suit, that consent decree, is supplanted by the terms. Now, that can never happen. A court decree can't go by a piece of writing between two people. I can't write to him saying, today, the decree is gone. That's what it seems to record. And on that basis, he's not made owner of the mark. He's given some kind of right to use it. Says perpetually. Use it. This is, so on that basis, although he's not become the proprietor, he has no right to apply for the trademark under that so-called agreement. He applies for registration. So when we find out, we naturally give him notice. We say, look, how are you using this? Now, his reply notice is very strange. He challenges my title, although he was manufacturing not under my license agreement. He challenges, he says, you were never the owner. You were never the owner. Your brothers are, after you left from that firm, you cease to have any right. This is really his case, his long and short of his case. Now, immediately, we also, cancelled that license agreement we had with him. So that is gone. Now, my uncles, when I tell them...
License agreement is cancelled, so who will manufacture?
I have any number of manufacturers. This is job work that is. He's a job worker. He's a job worker who's managing, and it's being sold under this. Now, if he's not going to, if he says that the decree is supplanted, then I have no obligation to have it manufactured by him. Although, perhaps, maybe he's a good manufacturer, I don't know, for whatever reasons, we've continued. Both branches are getting it manufactured by him. But if the decree is supplanted, I need not, I don't have a problem as long as he does not claim to be the owner of the mark. Now, uncles, I take it up with them that he is relying on this coexistence agreement. How could you have done it without the owner, without the knowledge of my trademark, of a trademark co-owner? So, they have also terminated that agreement. So, this is the given situation. Now, my lord, irrespective of whatever stand my uncles may take, my lord, 3 points arise over here, legal points before I show your lordship the documents. Number one, my lord, we are co-owners. Lord, no co-owner can deal with a trademark in a manner which is prejudicial to the interest of the other without his consent. I have the judgment, I'll just show that to your lordship. Number two, my lord, he is my licensee. My lord, a licensee can never challenge the title of the owner. My lord, that's well settled, whether in tenancy law or otherwise, my lord, or even trademark law or my lord, Evidence Act. My lord, your lordship knows estoppel under my lord, the under section 118, that's also coming to the new act. So I might just have a chance to show your lordship the new act for the first time. So, my lord, and the new act also I'll show your lordship. So, my lord, these are the three legal points. My lord, he can't challenge my right of ownership. Any right given by my uncles, if any, is void, my lord, or no good without my signature. A decree of the court can't go just by a piece of writing. In any event, my lord, whatever right has been given to him, my lord, has been cancelled by the uncles. Now, my lord, comes the tricky part. Up to here was easy. So, my lord, the exchange of correspondence take place. Now, my lord, I file the suit. Immediately after I file the suit, my lord, he also gives me notice on the same day. My lord, I file my suit sometime in the afternoon. Evening, he gives me notice that he has filed a suit in Delhi. So, my lord, I understand that his application is also listed today. Mine is also listed today. This is the situation I've been served with his suit. Now, my lord, I am first past the post at the moment, my lord. Let me try and take advantage of that. Now, my lord, if I can just take your lordship first to the decree, page 80. I'm sorry, my lord, it starts at page 80, not 8, page 80. I'm sorry, I was right, not page 80.
Yes.
My lord, your lordship will see the cause title first. JJ Electrical versus Mahavir Prasad Jain. Not at that point of time, my father was a partner. He was still alive. And my lord, your lordship will find, if your lordship takes the second para, plaintiff and the defendants have settled their disputes on the terms and conditions stipulated in para 2 of the application, which is marked so and so. And my lord, the judge, learned judge, my lord, he accepts the terms of settlement which are annexed. Now, my lord, if your lordship sees next page, para 2 of the terms of settlement, which is accepted. 2A, defendants admit right of the plaintiffs in the trademark JJ Deluxe and other formative marks. Not B, they admit proprietary rights in the artistic features and copyright not of these. Then, my lord, your lordship will, my lord, it's come twice. If your lordship comes to page 83, then, my lord, they admit my user from 1975, that's D.
Yes.
Then E, defendant admits various trademark registration of the plaintiff in the mark JJ Deluxe and other formative and undertakes never to challenge the same. Then, my lord, please see F, defendants undertake not to use the trademark so-and-so, so-and-so, so-and-so or its artistic features amounting to infringement or passing off. Then, my lord, sees F. Defendant further admits that at the earlier occasion, defendant was manufacturing electric goods for the plaintiff on job work basis under the trademark JJ Deluxe and other formatic marks, and no proprietary rights ever existed in favor of the defendant. So, my lord, up to 2014, if he can't claim to the proprietor, how does he not claim it now? Then, my lord, please also see, Lord G, plaintiff and defendant arrived at an understanding that the defendant will be manufacturing switch gears, being electrical goods under the trademark Deluxe and other formative marks for the plaintiff and at the instance and instructions of the plaintiff. Goods so manufactured by the defendant will be supplied to the plaintiff or any other person at the instance or instructions of the plaintiff. Goods, defendant said manufacturing is strictly on job work basis. Defendant will not claim any proprietary rights in the trademarks. Defendant shall be manufacturing on instruction of plaintiff JJ Electrical as also on behalf of plaintiff's other associate firms, etc. So also not associates. Then Lord I is he will not do it for any other third party. Then Lord J, he will withdraw Lord his pending applications, etc.
Yes.
Then Lord I give up my claim to damages in view of the above is J. And Milord, I is, it will bind parties, representative, heirs, assigns, etc. So now, Milord, his son has also come into the business, which is why there are two defendants instead of one. So, Milord, this was the decree. Now, Milord, after this decree, your Lordship has seen he could not have applied for these marks.
Who has applied for mark?
Milord, I'll show your Lordship the application. Yes.
Undefended number 1 and 2.
Milord, it seems from the records that we find that the father has assigned rights to the son. And the son has applied, which is at page 217. Volume 2 নেই কিন্তু আমার কোথায় গেল
Yes.
Your Lordship will find Manish Kumar Jain, proprietor of Mahavir Sales Corporation, who's the defendant number 2. No, 1. He's the defendant number 1.
Yes.
Then, my lord, your Lordship will find not on this, not next the label, not that same JJ Deluxe label, which is already registered in the name of the firm. And your Lordship will find on the next page, mark is used by the applicant since 1st January 21. Now, I'll show your Lordship, my agreement with him is subsisting at that time. He's manufacturing for me. So he could not have. License agreement.
Yes.
Now, my lord, for that, my lord, if your Lordship now, my lord, takes page 213. Oh, what's that? 213. To whom it may concern, we, Tushar and Kshitij Sharaf, who are the plaintiffs, my lord, son of Rajesh, etc., do hereby enter into an agreement on 13th of July 2018 with Mahavir Prasad Jain, son of so-and-so, that Mahavir Corporation will manufacture switchgear items like main switches, changeover fuse units, DB boxes, MCBs, bus bars, and other related products in the name JJ Deluxe Classic on our behalf. Mahavir Sales Corporation will not sell these products with the above mentioned brand names to any other party pan-India. We also ensure we will purchase these products with the above mentioned brand names from Mahavir Corporation only and do business fairly. So, informal kind of agreement, but very much not mutual symbiosis. He will make for me and for no one else, and I will purchase from him only. But he is making on my behalf. And that's what the box reflects. Then, my lord, if your Lordship turns to 214.
What is your firm's name? JJ.
JJ.
And here.
JJRS.
JJRS.
JJRS Enterprise.
Page number 213.
Yes.
Mahavir Sales Corporation will not sell the products of so-and-so on the front. We also ensure that we will purchase the products with above mentioned brand names from Mahavir
Sales Corporation only. But that is defendant. So I will purchase from him. I will purchase from him. He is doing job work. My lord, it's a job work contract. I will purchase from him. And my lord, he is doing it on our behalf. My lord, please turn the page 214. Then, my lord, agreement for supply. Not again between the same parties. And if your Lordship comes to page 215, 1B, products must be supplied in accordance with specification of the company, blood, which is us, with respect to logo, design, printing matter, marking on the packaging. So, blood, that's mine. Then, blood, C, manufacturer, meaning him, undertakes that the company is the absolute owner of the trademark and shall not supply products under the brand name JJ Deluxe to any or any other JJ brand to anyone else.
Yes.
So, blood, after this, could he have applied during the pendency of this agreement? And Lord, this is for a period of 10 years. Please see this.
Yes.
Duration, clause 2.
Yes.
The agreement is for 10 years.
30.
So, my lord, therefore, my lord, what is at page 217?
Yes.
My lord, his application, my lord, couldn't have been done. Now, my lord, please compare this with page 122. If your lordship compares 217 with page 122. Now, my lord, please see it's identical in all respects. All respects. As my trademark application.
217 is the defendant.
Yes, yes.
Manish Kumar Jain, proprietor.
Yes. Now, my application, Lord, and if your lordship comes to page 121, your lordship will find this is the Lord registered mark of the old firm, Lord.
Page number?
Page 121, just one page before that.
Yes.
So this is not old registration, Lord, of 1994.
Yes. Of the apprentice.
Yes. So, Lord, it's an old mark. We've been there for a long time. He has applied. Now, Lord, which leaves me with not the notices. Now, your lordship has seen, Lord, this trademark application. This is contrary to the decree. It's contrary to the terms of the Lord license agreement. Now, my lord, I suddenly discover his application, and now, my lord, your lordship has seen the packets. So after he does this, my lord, he comes up with these, but little variation, removes my name from the front and from the side. Now, my lord, I write a legal, my lord, I send a notice to him. That's page 392. That will be at volume 3.
Yes.
Rather, my lord, page 390. Yes, 392. So, my lord, on 14th of June, 2024, Lord, I make all these grievances. Lord, I am not reading your the letter. More or less, Lord, reflects my arguments, I guess. Lord, now, my lord, also, my lord, thereafter, at page 396, your lordship will find that that agreement which I showed your lordship was terminated by us. So,
392 is the cease and desist notice.
cease and desist.
And 396?
I terminate. Now, my lord, he sends a reply to my cease and desist, which is at 398.
Page 398.
398.
Yes.
Now, my lord, if your lordship, I won't read the long letter, but your lordship will see a few paragraphs. Page 400. At 400, para 6. Now, he admits the suit. He admits the consent decree. He admits that Mr. Jain, Manish Mahavir Prasad Jain, admitted the proprietary right of JJ Electrical, para 6. Please see that. And he agreed to withdraw the trademark applications and registrations. Now, if I may read para 6, suit bearing 2014 got settled, disposed of by an order in view of the undertaking given by Mahavir Prasad Jain before Delhi High Court. Mr. Jain admitted proprietary rights of JJ Electrical in the trademarks, JJ Deluxe and formatic trademarks, and agreed to withdraw the trademark application and registrations pertaining to JJ formative marks and not to use JJ formative marks without leave and license. So, my lord, he admits this. Then, my lord, he goes on to not para 8. Now he talks about this coexistence agreement. Para 8, JJ Electrical Industries agreed to enter into an understanding for perpetual use with Manish Jain on one-time consideration of 10 lakhs and accordingly payment of the said amount. JJ Electrical Industries with a deed of agreement gave consent for perpetual coexistence of etc. etc. So, my lord, he's talking about a coexistence agreement. I'll take your lordship there. Then, my lord, please turn to para 9. Now, this is, now, my lord, he has to explain why my signature is not there. Because if my signature is not there, he could not have. So in para 9, please see what he says. On retirement of your clients from firm JJ Electrical Industries and thereafter reconstitution of the partnership, wherein these are the plaintiffs, Prabhat Saraf and Praveen Saraf are the only partners, your plaintiffs have no right over the trademark JJ Deluxe. Now, is it his business how I retire and what I get? And, if I did not, then why is he not, on what basis is he not under a license agreement granted by Prabhat Saraf and Praveen Saraf? If they had no right?
So they have taken the benefit because that was with your father. So he has written new constitution.
No, they are not saying it's not binding on us because it's for your father. They says it was binding, but there is a new agreement now I have. Yes, there's a new agreement I have. Now I'll take your lordship to that. But he says you have no right over the mark.
Correct.
And para 10, you are falsely claiming
Agreement date,
etc., etc. And you have applied for registration. That's all nonsense. So, this is really his case. He challenges my title. Now, in reply, our reply is at page 408. I'm just putting it on record. There's nothing really new over there. There's nothing much. Now, I'll take your lordship to this coexistence agreement. So, he is claiming a right under a coexistence agreement. Number one, he knows that that can't be valid unless he knocks me out as a owner. So, he says you're not the owner. Yes. So, this is the given situation. Now, please see the coexistence agreement, which is at page 262, Please take page 262. I'm sorry, I'm having to take your lordship between this volume and that volume. 262. But the Commercial Courts Act has made things a little difficult in this, as much as your lordship will find. One is having to annex everything.
Yes.
So, JJ Electrical, this is an agreement of 25th of July 2023.
Yes.
But it's immediately after this that he applied for that trademark. Your lordship has seen that trademark application. So it must be on this basis. Now, please see the fifth recital. Whereas the predecessor of the party number 1, which is JJ Electrical, were also carrying out the said goods and businesses under partnership and constitution, which got changed from time to time by ingress and egress of partners.
Yes.
Now see, he admits that my father is a partner. Rajesh Kumar Saraf and Praveen Saraf and Prabhat Saraf were partners with a deed of 2014. I have annexed that also, although not necessary. On death of Rajesh Kumar Saraf, his two sons, Tushar Saraf and Kshitij Saraf, were inducted in the firm. So, I became a partner.
Yes.
Via partnership deed of 2017. On 25th of February 2019, Eshad Saraf and Kshitij Saraf retired from the partnership, and the time was then reconstituted with the partnership deed of so-and-so between the two remaining partners. Now, so therefore he is now saying, I have no right, not in the firm, but it won't take away my right in the mark. Now, whereas the party number 1 is the owner and registered proprietor of JJ Deluxe, duly registered under so-and-so in relation to switches, whereas party number 2, through his predecessor, has been engaged in manufacturing and was manufacturing goods for party number 1. Please mark this. Whereas predecessor of party number 2 got the trademark label registered under so-and-so and filed a civil suit. He acknowledges it. He then acknowledges the decree. Now, please come to the third paragraph. This is where my problem starts. Whereas, page 264, third paragraph. Whereas in supersession of the said settlement between the party number 1 and predecessor of party number 2. So, please mark predecessor of party number 2.
Yeah.
And party number 1. The party number 2 approached the party number 1 for grant of consent for coexistence for the purpose of perpetual, uninterrupted and unfettered use and exploitation of the mark JJ Deluxe. Now, my lord, my father was also part of that company, is a party to the terms of settlement. Now, the point is, by this agreement, can you supplant a decree? A decree can't go by a simple letter. You have to go and have the decree set aside or modified. Till then, my lord, it stands. It's simple as that. And without my consent, that could not have been done. Then, my lord, whereas party number one has agreed to enter into an agreement for grant of consent for coexistence of perpetual, uninterrupted, unfettered use and exploitation of the mark upon one-time consideration of 10 lakhs. Now, my lord, it's not very clear not what right he's getting other than coexistence. It does not say he will become the owner of the mark. It does not give him the permission to apply for it on his own. It says the two of them will coexist.
Correct.
Now, my lord, now this did witness it. Not same thing. Party number one gives consent for coexistence, perpetual, uninterrupted, unfettered use, not one-time payment. Then, my lord, party two shall manufacture and sell electrical goods under JJ Deluxe without. Now, my lord, this is the clause 2, bottom of page 264. This is very important.
Yes.
Party number 2 shall manufacture and sell electrical goods under the trademark JJ Deluxe without any control or supervision of the party number 1. However, party number 2 will have to fulfill all statutory obligations, etc., for sale of electrical goods. So now, my lord, he has given control of the mark in a way. He says you can do it in any way without my supervision.
You are the party number 1.
No, I am not a party.
That's why.
The uncles,
That's why
defendant numbers 3, 4,
correct,
are entering into this deal with defendant number 1 and 2, giving him uncontrolled right without making him the owner.
They are entering in between themselves.
Yes.
Because the party number 1 is the JJ Electricals.
Yes, that is, my lord, defendant numbers 3 and 4. My uncle's firm.
Yes.
My uncle's firm. Now, uncles are entering into the settlement.
And the Mahavira.
Mahavira is defendant numbers 1 and 2.
Yes. Yes.
So, my lord, it gives him a right to manufacture without control and supervision. And that is the objection. Because, my lord, if you allow a trademark to be used without control and supervision, your lordship has seen my agreement under my control supervision. The moment you do that, you are allowing, my lord, grip over the trademark to go away. And, my lord, now your lordship has seen he is making it without putting in the name JJRS or anyone. He has applied for, my lord, registration as if he is the owner. Now, my lord, please also see clause 4 of this. He suspects that this is going to be challenged. He knows it's going to be challenged because it can't be done in law and it's against the decree. This agreement is entered into by the parties without force, coercion, and undue influence. Lord, this is as if it's not a plaint now being filed. So, Lord, these are the facts over here. Now, in this situation, not just a few lines from 2 judgments, not at the interim stage, otherwise not necessary. Not the principles I've told your lordship, not joint owner of trademarks, not he can't not affect my rights in any way. Number 2, Lord, he is my licensee. He can never claim to be the owner. Not, let me just show your lordship 2 judgments, not just a few lines, not necessary, but not these are too well settled. No. Yes. Mm-hmm. What are the? The Delhi High Court judgment by Justice Ravindra Bhatt, who later went up to the Supreme Court. Now, my lord, if your lordship would turn to para 6. Now, my lord, your lordship has seen that coexistence agreement, my 2 uncles, being the defendant numbers 3 and 4, have purported to deal with it as if they are the sole owners. Now, my lord, please see para 6 over here. Similar case here. Plaintiff averts that in March 2007, he came to know that the first defendant had circulated a book titled Imperial, written by so-and-so, in the hotel rooms wherein the first, second, and third defendants projected themselves to the sole promoters and owners of the hotel and sole owner of the trademark, despite knowing fully well that the plaintiff is a joint owner. This is the situation. But one thing I forgot to show your lordship, not factually. But my uncles also admit I'm a joint owner, and they have also cancelled this coexistence agreement. I'll show it just after I show the judgment. I forgot to show your lordship that factually. Then para 7. Upon further inquiry, it is claimed that the plaintiff found that the fourth and fifth defendants had applied for registration of the trademark and several other trademarks, of which Imperial formed an essential feature. And then it's alleged that this is passing off. I won't trouble your lordship with this. Now comes to para 9. Places reliance on a English judgment. Counsel sought to place reliance on Sir Robert Alpine to argue that one co-owner of a goodwill cannot, by way of misrepresentation, elbow out or deprive the other co-owner of the benefits of such goodwill by appropriating it. He submitted that since both the plaintiff and the first defendant were joint owners of the trademark, trade name, and goodwill, the first defendant's action to appropriate that goodwill in respect of the third and fourth defendant entitles to the exclusion of the plaintiff, defendant entities to the exclusion of the plaintiff would amount to passing off. So, this is the argument made. Now, if your lordship comes to the findings, please come first to para 19. Just one line from there. The last sentence. 4 lines from the bottom of para 19. The first defendant does not dispute joint ownership of the trademark or the goodwill and reputation associated with it. In these circumstances, the question is whether plaintiff is entitled to interim reliefs. Then, please come to para 20, which is a quotation from that same McAlpine case. Can I, based on that, the learned judge goes through it and he holds that at para 21. I'll just keep it short. Para 21. The above ruling, para 21. The above ruling establishes that a joint owner of a trademark, as in the case of joint owners of other property rights, cannot act so as to diminish the right of the other part owner without his consent. A sole owner's right cannot be diminished or impaired. Equally, a joint owner cannot be so injured, be it at the hands of the joint owner or a third party, including in the circumstances, in view of the admissions of the first defendant as regard joint ownership of the trademark. I'll show your lordship the admission here. Yes. The court is of the opinion that no new mark or modification of the mark can be brought about unilaterally by one joint owner. First defendant may be able to establish at trial that the change by introduction of a motive does not dilute, diminish. It's sufficient to notice that introduction was without the plaintiff's consent. And then, the last 4 lines of the para. Therefore, neither the joint owners, i.e. the plaintiff or the first defendant, can unilaterally and without the other's consent or use or cause the mark to be used in a manner that would injure the goodwill or reputation associated with the mark. Yeah. And then, if your lordship sees para 22 right at the bottom, the last sentence on that page, this court has held that unilateral use of jointly owned trademarks can injure the rights of the other owner. Applying the same logic, when such joint owner can't do directly, can't be achieved by him through use of stratagems such as closely held companies or family firms, etc. So, what you can't do directly, you can't choose to do through defendant numbers 1 and 2. This is the situation, and injunctions were granted. Now, the second proposition, JK Jain. Yes. If your lordship, there's no para numbers here, but if your lordship would take the third page, if your lordship takes the second page, the second para, the last 4 lines from the bottom, the plaintiff respondent claimed that the license to terminate it. So, similar case, licensee trying to use the mark, which were magazine names, PC magazine, etc. And the plaintiff claimed it had been terminated. These are the facts. Now, please turn to the third page. The para beginning with, we have heard counsel for the parties. First para on top of the third page. Page 808. 808? Yes. You've given some other version? Yes, we have. Yes. We have heard learned counsel for the parties at length and also taken through the record as noticed by the bias above by us, the learned single judge, after considering the fact that the plaintiff had granted a license in favor of appellants on 1994 and the term had expired, observed that the defendant appellants had, under the terms of the agreement, recognized the respondent's proprietary right in the copyright under the agreement. Now, your lordship has seen he has not acknowledged all our rights. Therefore, as an ex-licensee, appellants were stopped from challenging the ownership of the respondent in the marks. So-and-so, 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 in any way, not as descriptive marks. As an ex-licensee, appellants were stopped from claiming that the marks were descriptive, since the appellant, under terms of the agreement, were unable to challenge the proprietary rights of the respondent's trademark or trademark on any ground. Then, my lord, also see, my lord, 7 lines from the bottom of the paragraph on the question of irreparable loss. Also, learned single judge observed that mere undertaking to publish disclaimer continuously was not going to help, and unless injunction was granted, plaintiff was likely to suffer loss, etc. But there's more there, but not if your lordship not comes to the last page, not the second last para at page 810.
Yes.
Not looks at Wanda and Antox, and then Milord, third line, the entire case of the plaintiff respondent is based upon the premises that the defendant appellant deserved to be restrained from violating the terms of the agreement entered into between the parties, in which the appellant had admitted ownership of the plaintiff and its associate in 4 titles after termination of license. The very act of the defendants in publishing the 4 titles is contrary to the terms of the license.
Yes.
So, not the appeal was dismissed, the injunction continued in this matter. So, not this applies not squarely in the facts of our case. Now, not that leaves me with showing your lordship that not they have admitted, not the termination by my uncles, and they have no objection to my rights. Not that termination, your lordship will find it page 414. Not I have showed your lordship. Not I have not terminated. My termination letter I have already showed your lordship. And this is not, that's not page 414.
Yes.
What's termination? And Mulot, 414, Mulot, is written by the defendant number
1. Prabhat.
Defendant number 4.
Yes.
Defendant number 4. So, my lord, he has cancelled that coexistence agreement. And, my lord, he acknowledges my rights. Not they acknowledge my rights in relation to the mark at all times. And that's how I've been using it all these years. Not that your lordship will get from page. The affidavit type.
No, this 414 is the notice of the defendant number 4.
Yes. Not cancelling the coexistence agreement. I have given your lordship my notice terminating my license agreement. This is coexistence agreement also not being cancelled by the uncles.
Okay, okay. Yes.
And he threatens legal proceeding. But if your lordship sees bottom of page 414, right at the bottom, terminate.
Terminate the agreement.
Yes. That's it. And my lord, your lordship will also see that they don't object. That is at page 390. He is
Yes.
so Prabhat Saraf, my lord, acknowledges the NOC given long ago, my lord, in 2019, and he says they are jointly owned. Jointly owned by Praveen Saraf, Prabhat Saraf, and Tushar and Kshitij Saraf.
Yes.
Not a third party can't come and challenge me, not my title when my uncles say I'm also a joint owner.
Yes.
Which leaves me with one last point, not which is this. Now he has filed a suit in Delhi. But he has filed a suit in Delhi, not challenging my right or claim over the mark.
Have you received the copy?
Yes, I have received a copy. I have a copy here. But not that's because I had filed a caveat. I had filed a caveat. I've received a copy. Now, we have received a copy after filing of our suit. Sorry, come again. I'll show your lordship. His is filed on 1st of August 2024. His registration suit is registered on 1st August and date of filing is 31st July. That is the case status.
Yesterday.
And mine was also filed on 31st July, but it was registered on 31st July. That I'm showing your lordship. So mine is the prior suit technically. And I did not have notice of his suit when I filed my suit.
Yes. Yes.
Now, my lord, it is clear. One thing is clear. Lord, it is in response to my notice, cease and desist notice and termination that he has filed that suit. Now, as I understand, we do have a copy of the plaint. But as I understand, he is not challenging the termination in that suit. He is simply challenging my right to ownership. Now, now, my lord, as I understand it, not first, as a licensee, he can never challenge my title. Number two, a challenge to a mark can only be decided as far as not limited knowledge, but largely not by the body not given that right, the IPAB, which is now the High Court or the registry. Now, be that as it may, I'm not going into the merits of the suit. Not the question is not as far as this suit is concerned. The subject matter are these marks. And, my lord, your lordship has seen the packets, they are identical. There is little by which any purchaser will think not twice before buying it, without knowing that the source, not that the owner is different, and today he is doing it without authority. Now, my lord, these are also not, please remember, electrical goods. These are some of the more basic ones, but there are others. Now, I don't say, my lord, it will cause too much of a difference because earlier I was buying from him. He is also selling now, not claiming to be the owner of the mark. Now, my lord, in those circumstances, my lord, there is no doubt a passing off is happening. A defense not based on a challenge to my title is not permissible. Not in those circumstances, my lord, please, my lord, pass an order, my lord, of injunction restraining him from using not these not packets, trademarks, not copyright, and all of that. Not today, his right, if any, which was there, stands terminated, and by the document he relies on, not the terms of settlement, not is gone. According to him, it is supplanted. Although I say it could not have been, but his own case is supplanted. Therefore, my lord, I have no obligation to get him to manufacture it. Maybe I will at the end of the day, but first, my lord, I have to knock off his claim to the trademark. Otherwise, my lord, I lose this valuable right. Not those are my suggestions.
ये मनोज 12 बजे बैठ में फिक्स बैठ रहे ऑफिस में नहीं
Lord, one other thing, Lord, as my learned junior points out, Lord, and I want to show it only for this reason.
What
it's
is
a
the
brand
prayer?
new.
What is the prayer?
Not prayer, Lord, I'm sorry, Lord. Page 52. If your lordship not considers, Lord, prayer B and C. Not using JJ Deluxe, not the word and Lord in that label. And using Lord identical packets. Not I've showed your lordship the packets. बेटा तो ओ अच्छा बोल भाई कैसे बार करो पातड़ा बार करो
B is
yes
B prayer is
should cover not more than
B
more
is
than
covered.
so.
Yes.
And Lord just not out of a sense of fun, my Lord, Bharatiya Sakshya Adhiniyam 2023. Not I'll have to improve my Hindi a little bit.
Bharatiya Sakshya Adhiniyam.
Yes, my Lord. That's section 122, which was previously 116, my Lord. It's the same, my Lord. Language is identical. no tenant of immovable property or person claiming through such tenant shall, during the continuance of the tenancy or at any time thereafter.
Section?
122.
New one. New.
The old one was 116. Covers both tenancy and license. Is your lordship's copy as brand new as mine? Lord, is it the first use?
First use.
That's why, Lord, I couldn't resist.
Because in this determination,
absolutely necessary. It will be. So your lordship can make a marking. It's at least this section is identical. 116.
Yes.
Not 122 is the same as 116 of the old act. No tenant of immovable property or person claiming through such tenant shall, during the continuance of the tenancy or at any time thereafter, be permitted to deny the landlord of such tenant had at the beginning of the tenancy a title to such immovable property. Semicolon. And no person who came upon any immovable property by the license of the person in possession shall be permitted to deny that such person had title to such possession at the time when such license was given. Now, this is more for fun, but not hopefully somewhere. I'll have to get more educated on this new act. I can't say I know fully what the differences are, but these juniors, they worked hard. They have
to. Thank you.
Obliged. But he will give his reply.
Three matters fixed today. 12, 2, and 3.
Item number?
21.
Ah.
My statement is here. So, for the appellant, will be taken up on 21 submitted on Monday, submitted your lordship's convenience. I see there are 3 matters fixed and it may go on.
21, 22.
Only 21.
21. Not today.
Okay.
21 not today. Huh? Yes.
I'll try and keep it very short. I'll just take 2 minutes to summarize what he has argued and what I have argued.
Yes.
My learned friend had argued, really speaking, for his claim in support of attachment and injunction, that, this is an admitted claim, and, apparently, I'm selling shares. This was his second submission. Third was the law of attachment has changed. It has undergone a sea change. And then, he had argued, he had tried to indicate in anticipation a defense to, the Commercial Courts Act. Now, what I had argued, if I may again just summarize in two minutes, that there are various legs to the transaction. My learned friend is referring to only one leg.
Right.
I had acquired, I'm sorry, I saw your lordship looking there.
Yes.
So, he had not referred to the fact that I had acquired the company through the NCLT, and it's difficult to go through this layer of companies. He said he has another layer from the bottom by which I cannot reach it.
Correct.
So, he sells me the Indian company, but I don't get control, of the company which is actually the lessee there. So, I've still not got control via this route either. Till today, his people are directors. So, I showed your lordship in my letter, I've denied, I've not categorically stated that he continues to be in control of that Georgian company. My people have not come. That is not disputed, not either in the plaint or elsewhere. So, the plant is under his control. Therefore, the letter of possession which he relied on, your lordship will remember, or do I just point it out once more? He relied on a letter of possession which is at page 78.
Yes, 78.
Page 78.
Page 70.
Yes. So, I'll not read it, but it records that I have received khas possession of the steel plant.
Yes.
And your lordship will find that we had visited 15 days earlier. So it is recording that 15 days before I took possession. But the date of this is 14th of April. It's on the same day as the agreement.
Correct.
So now, my lord, could I have actually been given possession without having paid a penny, without there being any agreement? Agreement is coming on 4th of April. Would someone hand over the plant to me and go? So it was only paper possession. That's my submission.
But in the fourth, 1, 2, 3, 4, 5, 6th
Yes.
line from the top
Yes,
bottom,
madam.
I have on this first day of April
Correct.
2023 received the
Received
first
first
possession
possession of the
plant.
steel plant, which has been handed over by Pulak Modi as accompanying me to the steel plant at Georgia for the purpose.
Correct.
A summary of the inventory and assets, etc., undertaken and confirmed is attached. So, my lord, this is clear that this is being done later as an afterthought. On first, there could have been no real handing over because there was no agreement. The agreement is coming on 14th. Number one. Number two, Lord, it's a company which is the owner or the lessee. It's for the company to hand over. If the company continues to remain in his control with his directors, Lord, how do I actually get control? This is simply a piece of paper. Rather than going to Georgia and handing over and making change of directors at the time of the agreement, this is signed. It is only a paper handing over of possession.
Yes.
No real possession. Because, Lord, as I said, it's a company, he continues to be, his directors continue to be there. This is being signed in India, Kolkata on 14th April, not in Georgia. So it is for documentation purposes and for creating a paper trail, that's all, nothing more.
Yes.
Admitted position, Lord, is that I only have paper control. I don't have control, even paper control over the Georgian company today. His directors are there.
Yes.
Lord, third thing I had pointed out was, Lord, in reply to his notice, Lord, I have given a reply saying clearly, look, the agreement could not be worked out because you could not give me possession. The plant was first shut down by environment people and thereafter by the ED. You said you will take steps. Till now, no steps have taken place. Here, please take back your shares and give me back my 1 crore. And I avoid the agreement. Now, Lord, in his plaint, he does not deal with the termination at all. He is not challenging the termination.
Yes.
Now, without that, Lord, can he get the relief he is asking for in this suit? Lord, besides the other legal points which I have. But there is no dishonesty on my part. I said, here, take back your money. Or rather, give me my money and take back your shares.
Yes. Next.
Not please see once more that termination letter, page 72.
Yes, you pointed out.
Yes. Now, there is no mention. He mentions the letter in the plaint, but he does not say that I have terminated. Or for that matter, in the petition. He is proceeding on the basis that the agreement subsists and therefore there is an obligation to pay money. But if the agreement does not subsist, where is the obligation to pay money? Unless you say that this termination is wrongful. Lord, please see the praise of the plaint, Lord. Lord, come, please take page 40. Simply a money decree. No declaration that the termination is wrongful. And Lord, how does he deal with this? Lord, please turn to page 35.
Yes.
But if your lordship would take page 35 once. How does he deal with my claim in the letter? Para 22. Page 35.
The same letter, 16th April.
12th April. My reply.
Yes.
By a letter of 12th April, defendants have issued a reply taking a purported plea contrary to the express terms of the contract. The contents are false, untrue, incorrect, and are denied. By the said reply, Not only did the defendant number 1, 2, and 4 deny the obligation to pay the balance sum under the contract on the ground of alleged misrepresentation for fraud, they called upon the plaintiff to refund 1 crore. Stand taken is contrary. Now, where is this not? The agreement has come to an end, therefore nothing payable. He's not challenging that. Then they reiterate and another reply. So, my lord, no challenge. Now, my lord, this letter, relief against that letter is not sought. But the next point which I had argued was, I showed your lordship the verification with regard to attachment. I don't think I need to repeat that. He says from the record.
Correct.
Now, no record, and there was no allegation that I'm disposing of any shares. That was paragraphs 34 onwards. Serious apprehension that my financial condition is bad. Not bare pleading, para 34. And this is based on record, no record there.
Yes.
Extreme urgency because I'm in the process of dealing with disposing of. Now, if you have it from the record, show me one property that I'm trying to sell. Then, my lord, para 35, he says respondent number 1 is in precarious financial condition. Out of 12 companies where the respondent number 1 is director, 4 have been struck off. Lord, he has the record, nothing disclosed. Now, Lord, if I say some of these companies were struck off 10 years ago, will it give him a ground for attachment? Nothing annexed. Then para 36 shows it is mere apprehension. Lord, petitioners apprehend that petitioner respondent 1 to 5 with
Yes, you find out a May.
And Lord, and he's asking for attachment. Lord. So, Lord, this was the other submission. Now, Lord, I just started off on his point. Lord, that this change in law. So, Lord, what's the law relating to attachments? Lord, of course, it would be a shortcut if I could only deal with it by saying my learned friend had relied on that, not judgment under order 21, your lordship, really, where the principles or the guidelines have been issued by the Supreme Court.
Yeah.
Now, very easy route for me, Lord, to avoid having to deal with these 4 judgments he's shown is simply to show one of your lordship's not orders where your lordship has considered it and said it's not applicable in all cases. Lord, it's as simple as that. But Lord, I will go into the legal principles relating to that to show that there is no change in the law. Lord, the law has always been, if I may put it this way, Lord, that Lord, an attachment in a money suit can be granted. Not that it can never be granted. Of course, it can be granted, but in extreme circumstances. Particularly in cases where Lord, someone with notice of a suit tries to dispose of properties to render the suit infructuous. And that is the Lord, that is the thinking behind all of these judgments, right from Lord 51 Calcutta onwards, Lord to Ramantek to Lord now. This is the thinking behind it. Now, it does not take away Lord the need or the requirement to show that I am Lord getting rid of properties or likely to deal with the properties. I'll just give your lordship Lord a situation. Now, Lord, let us say I am a poor man. Lord, will I not need to access my bank accounts? If I need to, Lord, the judgment says it's not a crime to deal with my own property. It's not a crime. It is only when it is being done with intent to defeat, Lord, the remove properties outside jurisdiction to defeat a decree. Now, Lord, here I've showed your lordship, number 1. Lord, these judgments, all of them, what they say is, you must have more than a strong prima facie case.
Correct.
It's not just prima facie case. To be able to do it, it has to be more than that. It has to be a very, very strong prima facie case. Now, here I'm showing your lordship, he has no prima facie case at all. Because the deal was, and here, Lord, I'll trouble your lordship once with the agreement. The deal was that, look, I want a shortcut to get control of that plant.
Yes.
It is not to get control of an Indian company. For that, my lord, if your lordship would take the agreement, which is at page 47. Now, my lord, please turn to page 50, the recitals. The company has a wholly owned subsidiary registered in Georgia and the name of Ambicon Steel. So clearly we are thinking of that. Although I'm acquiring shares here, having its registered office at so-and-so, Georgia. The said ASL runs and operates a steel plant taken on lease from Eurasian Steel, a limited liability company registered in Georgia, and the indenture of lease of 12th February entered into between ASL and ESL. Now, the sellers according, now your lordship will remember, because of NCLT, I have a right to actually come in from above. But in between, he has created this block and created a lease, which is what I mentioned in that letter. The sellers accordingly operate and control the steel plant through ASL, the wholly owned subsidiary of the company, wherein the sellers own and control 100% of the share capital, as would be evident from Part A or Part B of the so-and-so, so-and-so. The sellers through the corporate sellers have also provided in unsecured company loans, etc. Then, my lord, please see F. Purchasers have a potential interest in the said ESL and accordingly were keen to avoid future complications and disputes. In other words, I was coming in from the head, but to avoid further dispute, because he says he is in possession, I am also entering into a deal with him. And accordingly, upon discussion with the sellers, have therefore acquired full ownership and control of the company from the sellers and taken immediate possession and control of the steel plant on an as-is, where-is basis. What is basis? On the price and terms stated hereinafter. So the intention is to catch the steel plant.
Yes.
Not, my lord, because as I've told your lordship, this company has no business. The Indian company has no business. It has a 100% shareholding in the Georgian company, which is operating the steel plant. So, my lord,
so this page 50, paragraph F.
Yes, ma'am.
Cannot corroborate this page 78.
No, my lord, it doesn't. It's the same thing. Lord, again, let's go back. It's being done on the same day. They are being signed. Lord, please see that letter, page 70. Signed same day.
That's why. Same day, 14th,
Yes.
14th April.
Yes, yes.
14th April.
Yes.
Because
Keen
you
to
are aware.
avoid future complaints. So all I'm showing is intention is to get the steel plant. And Lord, what is this saying? And have taken immediate. Now, Lord, immediate possession and control of the steel plant. Immediate can't be at the time of agreement because we are sitting in Calcutta. Have taken immediate possession and control of the steel plant on a as-is, where-is basis on the terms and price. Now, I am not getting possession over here. Piece of paper is signed showing I have taken possession 15 days before the agreement of payment.
Yes.
Which could not have been because I had not become the owner of the shares. I had not become a director. Now, how do I take control of the asset of a company? Could not have been done in law.
That's correct.
So this is only not recording it. It's a mere piece of paper, but it is giving paper possession. And I also say, in fact, I have not got it because his directors still continue over there. So, not in law and in fact, I have not got it.
Yes.
But all that I was trying to establish, not at the moment, was that look, the intention was to get the steel plant, and the fact of the matter is, I do not have it. I have said so in my letter. There is no answer to this in the plain or the petition. He simply goes on, look, as is, where is basis. I am not concerned with whether the ED has read it or anyone has read it. This is his case. Very well. You agreed to open it. You have still not given me control. Give me control of the company. That also he can't do. Which is why I said, please take back the shares and give me my 1 crore. That's all. And Lord, the fact of the matter is from April, Lord, next money was due in July. From July till now, he has waited. He's come, Lord, 10 years later. Look at the massive delay. Now, Lord, I have explained the delay in my notice.
Yes,
Lord,
you stated all.
I have stated, Lord, that it was agreed that no payment till he can take steps to give me the company. He will take steps to reopen the plant. That is why, Lord, the other 50% owners, Lord, who are the defendant numbers 6, 6 to 9, did not ask for money. They did not ask for money.
Yes.
Nor did my learned friend. Lord, is there one letter asking for the money till now? So, Lord, now, Lord, your Lordship will remember, I have already showed it, page 71. Page 71. No need to not trouble your Lordship again and again. But page 71, fourth para. Till date, steps taken by authorized representatives to reopen the plant have failed to yield any result. We are patiently waiting for the outcome. And till date, the next para. Till date, you have been unable to give control and possession of a running
Yes,
steel
you
plant.
already
So I pointed all that. Lord, Now, my lord, in reply, they don't deny this. In the plaint also, they don't deny it. So they are in breach of obligations also. Now, my lord, let me now, my lord, just come straight to the law, my lord. Lord, the law on this, my lord, if I may just first start with, my lord, well-known judgment. I know, my lord, your lordship knows it very well, my lord. AIR 51 Calcutta, it lays down, my lord, 15 criteria, and that is followed by Raman-Tech.
Yes.
Now, my lord, basically, my lord, I'll tell your lordship, normally I would not have relied on this or Raman-Tech, because not this is now all considered to be not the usual good law, but not that verification. But there are 14, 15 criteria over there. He does not fulfill any of them, not one. And then he gives a verification. Not he has to show with not adequate, almost photographic evidence that I'm going to do something. There is only a bare pleading. Lord, let me just, for saving time, Lord, I say your lordship is not fully aware. I'm just giving your lordship a copy and pointing out the relevant para. Lord, AIR 1951 Calcutta 156. I had a copy though, I'll say. Lord, I only say, Lord, if your lordship not only sees the guidelines not laid down there. No, I had a copy there, otherwise I had forgotten it. I've not opened all this. But your lordship will kindly give me one moment. Lord, I had judgments for the other matter open. But your lordship comes to para 18. Now, if your lordship not sees not the guidelines, and Lord, on verification, Lord, if Lord, please come to para 10, Lord. I'm sorry. In this case, relevant para of the affidavit were verified as true to information, inquiry, and belief, but the sources of grounds were not disclosed. Then, Lord, judgments are relied on, and Lord, this question of how you verify it is not very seriously considered. And Lord, after all that, Lord, if your lordship then comes to para 18, from perusal of the authorities, I think the following guiding principles can be deduced. Order under Order 38 can only be issued if circumstances exist as stated therein. Whether such circumstances exist is a question of fact that has to be proved to not market satisfaction of the court. Court would not be justified in issuing attachment before judgment or security merely because it thinks that no harm would be done. Then, my lord, 4 affidavits in support of the applicant must not be vague, must be properly verified. Where it is affirmed as true to knowledge or true to information or belief, it must be stated as to which portion is true to knowledge. Now, my lord, please permit me to pause here. Lord, this is as vague as it gets. He has only set out not the provision. There is nothing. And my lord, is verified as record, no record given. Then, my lord, 5, mere allegation that the defendant was selling of his properties, not sufficient. Particulars must be stated. Not this is good enough to take me out. Not all these guidelines are there. Not he doesn't fall in the guidelines. This this judgment is quoted with approval in Raman-Tech. Not I'm not citing it. Not your lordship is aware of it. I'm not citing it. Now, not I'm only trying to address this because not it's a little serious issue. It may have ramifications in many other matters, which is why, my lord, I'm just dealing with it. My lord, there is no change of law is what I'm trying to show your lordship. So for the record, my lord, I'm giving your lordship Raman-Tech, and your lordship will find it, Lord, it approves Premraj Mundra. Lord, please turn to para 6. Or, my lord, before that, if your lordship sees para 4, Lord, just after placitum, Lord, just before placitum D, it is well settled that merely by giving a just or valid claim or a prima facie case will not entitle the plaintiff to an order of attachment before judgment, unless he also establishes that establishes is the word, not is attempting to remove or dispose of assets with the intention of defeating the decree. Equally well settled is the position that where the defendant is removing or disposing his assets and attachment before judgment will not be issued if the plaintiff is not able to satisfy he has a prima facie case. Then, my lord, please see para 5. Power under order 38 rule 5 is a drastic and extraordinary power. Such power should not be exercised mechanically or merely for the asking. Now, my lord, he is asking for this as a matter of, my lord, asking, nothing more. It should be used sparingly and in strict accordance with rule. Now, my lord, the rule says that not a notice to show cause must be given before attachment. My learned friend is at the threshold, not asking for it all. Then, my lord, any attempt by the plaintiff to utilize the provisions of Order 38, Rule 5 as a leverage for coercing the defendant to settle the suit claim should be discouraged. Instances are not wanting where bloated and doubtful claims, etc., by unscrupulous plaintiffs by obtaining orders of attachment. Then, my lord, para 6. A defendant is not debarred from dealing with his property merely because a suit is filed or is about to be filed against him. Shifting of business from one premises to another on other premises or removal of machinery by itself is not a ground for attachment before judgment. A plaintiff should show prima facie that his claim is bona fide, valid, and also able to satisfy the court that the defendant is about to remove or dispose of the whole or any of his property with intention of obstructing a decree, etc. Court should also keep in view the principles relating to grant of attachment before judgment. See Premraj Mundra. So, my lord, those principles get engrafted. So, my lord, this is the second judgment. My lord. Then, my lord, in this line, my lord, Calcutta High Court had said that injunction can't be granted in money suits. Now, my lord, I'll not say that this is all old water. I'm just giving your lordship the Now, my lord, these are considered in a lot of places because the reason I cite it is because the last judgment which my learned friend Millard showed. It's only because of that. Otherwise, wouldn't have bothered. But please turn to para 17. Now, it's a division bench judgment by Justice Bhaskar Bhattacharya. And my lord, if your lordship turns to para 17. Yes. First, whether in a money suit merely because the plaintiff has a strong case on merit, a court can restrain the defendant from transferring or alienating his immovable property. And secondly, whether in the absence of amendments made in terms of Order 38, a court can in a money suit grant an injunction. So, my lord, these are the two issues which came up. Now, my lord, please turn to para 21. Once we hold that in a simple money suit, an immovable property for the construction of which money is allegedly payable to the defendant cannot be property in dispute in the suit, clauses A and C of Order 39 cannot have any application. So, my lord, Order 39 can't be used, in at least not A and C. And clause B may be applicable provided the condition mentioned therein is present. So, my lord, Order 39 Rule B. Now, my learned friend is actually not even relying on that. He was relying on Section 151. Please keep this at the back of the head. It's important, my lord, if your lordship follows the narrative, my lord. Then, my lord, please turn to my lord, para 23. Your lordship will find Ramantek is quoted. Ramantek and Premraj Mundra, my lord, it's quoted.
Yeah.
From here, my lord, if your lordship would come to para 25, applying the aforesaid principles in the facts of the present case, we find that the statement that has been made in the application for attachment for judgment was that the defendant was in ruinous condition. My lord, similar allegation here. And that if the decree was passed in the suit, plaintiff would not be in a position to execute the decree if the defendant was able to transfer the property. On the basis of such vague allegation, in our view, no order or direction to give security can be passed as held above. There is even no allegation that the defendant is trying to remove or dispose of property in order to obstruct or delay the execution of the decree that may be passed against it. Next question is whether, by invoking 151, the court could pass an order of injunction or attachment. Now, this is where my learned friend took it to. He said very well, Order 38, 39, no. But under 151, the court has the power. This is where he took it to. Now, my lord, please see. But I won't read the whole of it. I'll just give you a lordship, not little portions. Para 27, not of course, these are submissions, but not I'll summarize it for your lordship. Not inherent powers can be exercised by the court only in not exceptional circumstances. Then, my lord, your lordship will find that it goes on to quote some judgments. My lord, para 28, it refers to Padam Sen. And my lord, the quotation from there, para 28, Padam Sen, my lord, 61 Supreme Court.
Yes.
Lord, may be relevant. I'll just read that. The inherent powers saved by section 151 of the court are with respect to procedures to be followed by the court in deciding the issue. Cause before it, these powers are not powers over substantive rights which any litigant possesses. Specific powers have to be conferred on the court for passing such orders which would affect the right of property. Such powers cannot come within the scope of inherent powers of court in the matters of procedure, which powers have their source in the court possessing all essential powers to regulate its practice and procedure. A party has full rights over its books of account. The court has no inherent powers to forcibly seize the property. If it does so, it invades the right of the person. Then, my lord, please come to para 32. My lord, again, further, my lord, para 30, my lord, sum and substance of the two decisions of the Supreme Court is that exercise of powers under 151, a court can pass such orders which is not in conflict with the substantive right of a party, and such order is necessary for the ends of justice, provided there is no bar in the court for passing such an order, which must be procedural in nature. Then, not 32. In the case before us, the plaintiff wants an injunction restraining the defendants from transferring or alienating his own property, over which the plaintiff has no right or for attaching the property. And owner of property was unrestricted right of alienation, and such power cannot be curtailed unless the law provides for putting such restriction. Section 94 of the code, which is the substantive part of the court as opposed to procedural part, gives power to the court to restrict such substantive right of the owner in circumstances mentioned in the schedule to the court, of which Order 38 and Order 39 are inter alia part. If those circumstances under Order 38 and 39 do not exist, the court in exercise of inherent power cannot pass any order, the effect of which would be to interfere with substantive right of a litigant, as was the case in the case of Padam Sen. Therefore, the prayer of the plaintiff in these appeals cannot be granted in exercise of inherent power, because it will have overriding effect over the substantive right of the defendant. So, my lord, our division bench, my lord, says this very clearly. Now, my lord, the next in line, my lord, thereafter would be, my lord, now, my lord, my learned friend cited Rahul Shah. Now, Rahul Shah. Rahul Shah.
Yes, Rahul Shah.
Yes, but he cited Rahul. Now, my lord, your lordship will find that, my lord, this is in relation to execution proceeding. Lord, your lordship has a copy, or do I give you?
I am having.
Yes. Now, in that, my lord, situation, your lordship will find that, my lord, the court is laying down certain guidelines, my lord, which are applicable.
Page 40, para 42.
Yes, para 42. Now, my lord, your lordship will find 42.1 will not apply to us.
He is relying over 42.7.
Yes. Now, so now, my lord, your lordship will find before that, my lord, if I can just place para 41, having regard to the above background, wherein there is urgent need to reduce delay in execution of proceedings. So, my lord, it's to reduce delays in execution proceedings. We deem it appropriate to issue a few directions to do complete justice. These directions are in exercise of jurisdiction under 142 read with 141 and 144 of the Constitution in larger public interest to subserve process of justice, so as to bring to an end unnecessary ordeal of litigation faced by parties awaiting fruits of a decree. Now, please mark this: execution and fruits of a decree in larger perspective affecting faith of litigants in the process of law. Now, where is his decree? My learned friend is proceeding on the basis as he admitted unimpeachable claim. I show your lordship agreement terminated, therefore he has no right to further money breached by him. Not after all that, not how is this applicable at all? It is to do with execution. It says there's a need to reduce delays in execution and, my lord, to prevent someone enjoying the fruits of his decree. But here his decree is nebulous today. It is nebulous. And then, my lord, 42.7, in a suit for payment of money before settlement of issues, defendant may be required to disclose his assets. So it's may be required to disclose his assets on oath to the extent he is being made liable. So, my lord, maybe your lordship could direct me to disclose my asset. But, my lord, to go further and say the court may further at any stage in appropriate cases during pendency using powers under 151 demand security. Now, my lord, has the court gone into this aspect of the law at all? Lord, two Supreme Court judgments, Padam Sen, etc., referred to by our division bench, say it can't be done under 151. By this sweeping power, Lord, is a High Court being given the power to attach properties under 151? It can't be.
Okay.
In an execution proceeding. Lord, this, according to him, was the basis of the change in law. Now, my lord, let us look at this explained. Lord, first, my lord, your lordship will see how the Delhi courts have treated this. Lord, this is reported in 2022 SCC Online Delhi 5637. Lord, para 3, your lordship will find suit for recovery of money, acknowledged claim. And then, Lord, reliance is placed on Rahul Shah in para 4 for the same proposition.
Yes.
This pragmatic approach, etc., etc. Lord, it's now, my lord, this is considered, and my lord, please see para 10 onwards. Further, the appellant, by filing applications under Order 38, Rule 5 and Order 39 CPC, cannot convert its secured claim into a secured debt, remand take. So, my lord, can't do that. Then, my lord, 11. Also, the Supreme Court in Rahul Shah was nowhere stipulated that it's mandatory for courts in each and every suit to demand security from the defendant in accordance with the prayer clause. The said judgment vests discretion over the trial court to direct the defendant to disclose assets or furnish security if the facts so warrant, and that too before settlement of issues. So, my lord, facts, do they warrant it? Your lordship is going into it now. But that would mean seeing whether the facts are in accordance with Order 38 or Order 39. Also, the judgment in Rahul Shah does not overrule the earlier judgment in Ramantek. So, Ramantek is still good law. Now, my lord, your lordship also, or rather, my lord, now, my lord, coming to lord, the judgment of my lord, this Tata, what's it called? Tata Chemicals. My lord, before that, my lord, this division bench has relied very heavily, my lord, on a case called Harleen Jairat, which is also widely quoted there. Now, my lord, if I can, before, very well, let me, my lord, deal with this also. Lord, can I show your lordship, Lord, just so that your lordship knows how this law has developed. This law, Lord, the division bench is based on a judgment called Harleen by Jairat by the same division bench. So, Lord, let's first look at this one. Now, Lord, again, these are cases of not extreme situation. Hey, I want to have it here. Okay. But please give me one moment. Lord, this one. But please turn first to para 44. But I'm not sure whether this is a submission or a finding. I'm just placing it. Not your lordship may not treat it as a submission, but it seems to indicate this. Para 44. The documents that explicitly showed that the alleged fraud committed by the distributors were put forward by Mr. Ratnanko Banerjee, appearing on behalf of appellant in both actions. So, Lord, documents, Lord, which explicitly showed fraud. Then, Lord, come to para 45. Any claim that the distributors were unaware of the pricing circulars was not true. Our attention is drawn to documents pertaining to the defendant's confessions, as well as their readiness to return specific amounts. So there was a admission, which I'll show your lordship later. Then para 46. Last 3 lines, reliance has been placed on balance confirmations forwarded by the appellant, which were never disputed by the distributors. Now, my lord, from here, my lord, if your lordship would come straight to para 96.
Yes.
Well, these are findings. It is clear from the order dated 17 July that the interim order was passed in favor of the appellants after the parties were extensively heard on points that are now being urged before us. Documents that are now being relied on by the appellants for part of the record. Respondents in the affidavits have not come out with any document to contradict the findings arrived by KPMG and later on BDO. These are during forensic audit. So there is not findings of fraud there. Both the reports show that the respondents have knowledge of irregular transactions and they were consulted before the reports were prepared. Email exchange between SKS and dealers during the period are not seriously disputed. In the affidavit, all the respondents have opportunity to deny the existence and contents of the mail. SKS has created a separate ID with passwords for the aforesaid transactions, which clearly go to show mechanism was clearly adopted to benefit the parties, etc. Then, Lord, please turn the page and your lordship will find admissions. Lord, third line from the top, there was no necessity for the dealers to admit receiving credit contemporaneously. They were in the know of things. Then, Lord, two lines below that, immediate reaction was conciliation, not denial. They stand in the affidavit is of confession and avoidance. So they admit the fact. We have repeatedly asked the learned counsel for the dealers whether the earlier periods they had received credits over and above the maximum cap for credit or rebates. We do not receive any satisfactory answer. They don't disclose this, that. Then, my lord, please see the comment at the bottom of para 97. Now, this was placed by my learned friend. The growth of economic activities in its myriad forms have resulted in significant changes in commercial law. Commercial transactions are primarily based on utmost good faith and confidence. But this is the exact situation here, that he will give me control of the Georgian company. Lord, he could not. He did not ask for money. And now, my lord, seeing that he can't, Lord, give me that a running plant, he asked for this. It is important that in a commercial relationship, like any other relationship, there must be mutual trust and respect, etc. And then, my lord, please come to para 100. Now, here, my lord, Harleen Jairat is quoted, and your lordship will find that this is the place from where the court is inspired to say, I can do it. Now, my lord, please see. Lord, please turn the page. Para 35 of Harleen Jairat is quoted.
Yes.
And, my lord, if I may just shorten it, not bottom of the page. While Order 39, Rule 1 and C refer to property in dispute, Order 39, Rule 1B does not put any such restriction on the phrase to remove property or dispose of with a view to divert creditor. The property contemplated under Order 39, Rule 1B may not be property in dispute in the suit. An injunction can also be granted by court to restrain a threatened removal with a view to defrauding creditors. Now, please see. If the court is satisfied, it can't be mere allegation. Court must be satisfied that the defendant intends to remove or dispose of his properties and his intention in doing so is to defraud his creditors. Injunction under Rule 1B can be granted. Such property may be movable, immovable, unlike Clause A and B, which is not restricted or limited to the property in dispute. Hence, Clause B can be invoked if the property is wholly outside the subject matter. Now, my lord, the only thing is that threat or intention to remove or dispose of the property to defraud creditors must be supported by sufficient particulars. So, this is, my lord, the root. Then, my lord, please see. Lord, it quotes another para 39, and then, my lord, it does not quote paragraph 40 onwards, which is what I will show your lordship after this, my lord. Now, my lord, from here, my lord, if your lordship would come, my lord, to para 110. So, my lord, what is being discussed is, if there is no power in a given case to exercise powers under Order 38 because the conditions are not satisfied, or under Order 39, can I do so under 151? That's now being considered. Now, my lord, if your lordship comes to 110, if there were doubts about exercising power under any of the aforesaid provisions. But in para 109, they refer to order 38 to order 40.
Correct.
It can be safely stated that the court has inherent power to pass an order of injunction or attachment upon, now my lord, please see it, an unimpeachable liquidated claim being demonstrated upon it being established that the respondents are taking steps to improperly deny realization of the claim. Now, where is that over here? Three things: unimpeachable claim, established that respondents are taking steps to improperly deny realization of the claim.
Correct.
So, my lord, court is, my lord, at least noticing this much here. So, my lord, where is the change in the law? My lord, let us say under 151 is being done. My lord, is this not exactly in lines, my lord, with order 38 or 39? So, same conditions must apply. Similar. Then, my lord, please take page 1, para 113. The plaintiff first has to cross the hurdle of prima facie case before the other factors are taken into consideration. Undoubtedly, the facts disclosed in the petition, read with the initial admission of the dealers and SKS, and the two detailed reports clearly establish a strong prima facie case. The confessional statement, read with two reports, and the acquisition of property of SKS, holistically viewed, lead to an inference of an unholy nexus amongst the parties to make wrongful gain. It is also prima facie established that the claim of the appellant in the nature of an unpaid vendor to the extent of excess credit or unauthorized rebate, DHOS, the claim is quite substantial, etc. There cannot be any doubt that both reports are expert opinion, and such reports are not per se admissible unless proved otherwise, etc., etc. Then, my lord, if your lordship sees para, lord, 120.
Yes.
Now, learned judge observed, but this was up before the appeal court. Now the question is whether not the discretion can be interfered with lightly. The learned single judge observed that collusion and fraud highlighted by the given documents were unimpeachable. But fraud, unimpeachable fraud, it's a very high standard. And my learned friend comes and says, look, I've come here, please, for the asking, give me an injunction under 151. These are high standards, my lord. Then, my lord, please, from here, take 123. The facts are overwhelmingly in favor of the appellant to justify an interim order. Para 124, an unimpeachable claim for money being established, the court, in our view, is entitled to pass an order of injunction so that the decree ultimately passed may not be rendered nugatory. It, however, depends on the facts and circumstances of the case. Then, my lord, from here, my lord, if your lordship would please take para 130. Para 132. Now, my lord, it's distinguishing a judgment called Jai Balaji.
Yes.
And, my lord, in doing that, please see para 132. It was on that background that the following observation was made. The claim in damages has to be ascertained. Apart from the amount indicated by way of liquidated damages, there may have been a genuine pre-estimate that was recorded by the parties. The rest of the claim has been assessed. Even the amount claimed by way of LD, which is less than 1%, may overlap, etc., etc. Lord, then, my lord, please see the last line. Last three lines, my lord. Work has been abandoned together with the petitioner's version is believed, or the contract has been repudiated if the respondent's version is to be believed. So, my lord, that becomes a very relevant factor, and I'll show your lordship one judgment on that point, my lord. Then, my lord, it goes on, my lord, to say, my lord, if your lordship turns the page, my lord, last 6 lines, a very strong prima facie case is an essential first step to an order in the nature of attachment before judgment. So, not just attachment before judgment, but in the nature of. Unless a near unimpeachable claim in money is apparent, there is no need to proceed to the second stage of assessing the conduct of financial capability.
Yes.
Then, my lord, please take para 134. In the instant case, the appellant has not prayed for attachment before judgment. Now, here, my lord, your lordship will find it's very strange. There is no prayer for attachment before judgment, but he uses the word attachment all through the draft. The aforesaid judgments are to be read contextually. It cannot be read as in statute. In fact, the last referred judgment of the learned single judge has indicated circumstances where an order for security can be allowed. So, and that is how it goes on to say. But not the test, as I've showed you, then it quotes from Rahul S. Shah at page 136. And that is what this judgment is. So, the standard of proof of prima facie case is increased in threshold. The nature of proof required even under 141 has not been reduced. If anything, not exactly those guidelines apply, not going by this. May I also show your lordship, this relies on that judgment of Jairat, extreme case of fraud, admitted claim, exactly the same thing. You want to multiply the fraud? It's based on that. The real paragraphs which on the basis of this is based, is not quoted there. It stops at para 39, but it stops at para 39, but there are a lot of relevant paras there, which would show it requires an extraordinary high claim.
Yes.
No point. My learned friends have not showed it. It's based on that. That's good enough. No point increasing the authorities. Now, my lord, which finishes my submissions and dealing with his judgments on attachment before judgment or principles to be followed. Now, your lordship has also considered this view. Page mascot petrochem. I'm sure it comes back to your lordship. And the first para your lordship will find it was for attachment of attachment before judgment and for furnishing security and for injunctions. And if your lordship comes to para 6, the pleading there was similar to us. He submits that defendants are maintaining a bank account and plaintiffs came to know defendants are trying to siphon off funds from the account to defeat the legitimate claim.
Yes.
And then, my lord, if your lordship, please come to para 13, the defendants relied on Ramantech.
Yes.
Your lordship considers order 38, rule 5. Then, my lord, please turns to page, page number need. Just after para 17, my lord, if your lordship would turn to para 17, where just after the portion where order 38 has been set out.
Yeah.
Just after that portion, learned counsel for the plaintiff, relying on the judgment of Rahul Shah, submitted that with pragmatic approach and judicial interpretation, court must not allow judgment debtor or any person instigated or raising frivolous claim to delay the execution of the decree. In suits relating to money claim, the court, your lordship, again realizes may, on the application of the plaintiff or its own motion using the inherent powers under 151 under the circumstances, direct the defendant to provide security before further progress of the suit. So your lordship is not recording, not what Rahul Shah says. In the case of Rajendran, Supreme Court held that while exercising jurisdiction under Order 38 is required to form a prima facie opinion, it need not go into the correctness or otherwise of all the contentions. Then, para 18, your lordship considers and quotes Ramantech. And your lordship has not noticed that same para which I read out, it's a drastic and extraordinary my lord, para 5 of Raman Tech is quoted. Then, my lord, if your lordship would come to para 21. The other findings. Plaintiff has filed the present application on the apprehension. Defendants may dispose of part or whole of the property owned by the defendants. Defendants are making efforts to siphon off funds from their bank account, maintained with UCO Bank. Plaintiff has made only a bald statement now, my lord, but has not filed any documents. Please mark this, my lord. Yeah. The defendant has made out a specific case that the defendant has paid the total amount. Defendant has relied on certain documents which are required to be adjudicated during trial. No evidence is brought on record to prima facie satisfy defendants are alienating their property and siphoning of funds. No material. And then Lord Raman Tech, Lord, your lordship is again quoted para 5, then para 24. Court considered the judgment relied on by the plaintiff, but finds that these said judgments are distinguishable from the facts and circumstances of the case. In this case, plaintiff has not made out any prima facie to get an order. Yes. Under Order 38, Rule 5. So, my lord, 151 not applied. 151 not applied. Your lordship has said, look, there is no sufficient case for Order 38, Rule 5. Now,
yes, next. Anything further?
Yes, but two small things I'll finish up. I'll finish up right away. Just two small points. Parabolic.
So it may be taken as a total hearing of.
Not it's as good. Not my learn. I tell you, lordship, I would have finished off on that day, but I was taken a little aback by not a submission that the entire law has changed. Not I had to do some. Not we had to do some serious research. No, your lordship is right. Not we should not be taking so much time in interlocutory matters. And not when I started off, not I was actually saying that not if it takes that much time to move it, then not deserves no order. But then not I am guilty of the same crime. To avoid an order, I am taking as much time as that. Now, my lord, if your lordship not first comes to para 32.1. Now, my lord, he has not challenged the fact that I am saying, look, agreement is now gone. Para 32.1, whether the original suit, sorry, not para 32 says, after perusal of the judgment and the questions of law framed by the defendant number 5 in this appeal, following points would arise for determination. Whether the original suit seeking a decree for specific performance in respect of a suit, scheduled property without seeking declaratory relief with regard to termination of the agreement or rescinding the contract is maintainable. Now, my lord, please now, my lord, come to para 37. As would be seen from the prayer sought for in the original suit, plaintiff has not sought for declaratory relief to declare termination of the agreement as bad in law. In the absence of such a prayer by the plaintiff, the original suit filed by him before the trial court for grant of decree of specific performance on the basis of agreement for sale and consequential relief or permanent injunction is not maintained. Therefore, we have to hold that relief sought for grant of specific performance, etc., is wholly unsustainable in law. Now, my lord, I tell you, lordship here, Lord, it's the same thing here. Because not his money decree is what? Seeking enforcement of the clauses for payment. So, not this would apply squarely. Not which leaves me with only one other point. Not these are of course points. Not I don't know. Not the application for revocation. My learned friend had argued two things in anticipation of our argument. Not revocation of leave under 12A. Now 2 points here. Not my learned friend tried to anticipate it. Two not usual points, not nothing much to it, nothing, not I don't think there's anything interesting over here. But there was a third point, which was an interesting one, which my learned friend brought up. Now, first and foremost.
Commercial court.
My lord?
Commercial court.
Yes, yes, yes. I'm sorry. I'll give a copy. A copy of what?
Yes.
Now, my lord, my learned friend anticipates. I say firstly, my lord, that not the question is whether this is a commercial dispute or not. So my learned friend has said that in his submission, he said that this falls within 2C1 ordinary transaction of merchant, banker, financial, trader. Then, my lord, he has also said it's could be 212 and lastly 218.
Yes.
Now, my lord, as far as this is concerned, my lord, 2-1 certainly does not relate to any ordinary transaction of merchant, banker, financer, or trader, or relate to any mercantile document. Now, 12, my learned friend, may have a case, but not your lordship will see, not if your lordship just goes back to the agreement at the heading once only, my lord. Your lordship takes the document at page 47.
Yes.
It's a share sale contract. It is not a shareholders agreement. What is a shareholder agreement? Both of us will be shareholders, and this will govern our rights inter se ourselves as shareholders. And I'll show your lordship judgments which say that is what a shareholders agreement. But an agreement simply or a document recording sale of shares, which is what this purports to do, will not be a shareholders agreement. It will not fall within 12. That much is sure. There's a Delhi High Court judgment, I can give it to your lordship, which says that this kind of a document will not be a shareholders agreement. But up to there, I must say, I think this point that we take is on a okay footing. My learned friend may have a better answer elsewhere, which I'll point out.
Yes.
If your lordship comes to para 22, be that as it may, I'm sorry.
Yes, yes.
It is further inquired from the counsel for the applicant as to under which clause of 2C defining commercial cause the present suit falls. Counsel for applicant draws attention to 212, which makes a dispute arising out of a shareholders agreement a commercial dispute. It's argued that an agreement for purchase of shares qualifies as a shareholders agreement. So this is the same argument. I'm unable to agree. A shareholders agreement denotes an agreement whereunder all shareholders or a shareholder of the company agree on the management of the company. ESOP scheme is merely an option available to an employee, etc., and will not qualify as a shareholders agreement. So, a sale will not. So, it will not come within 12. Now, my learned friend possibly has a better case, but he has not showed any judgment or anything. But under, he says 218. Now, if he says agreement for sale of goods or provision of service,
Agreement for sale of goods or provision. Yes.
now, for this he says, look, shares are goods. I have no dispute with that proposition. Sales are goods, and therefore he tries to bring it within it.
Yes.
But now, please come back to the agreement once. Please remember, it relates to agreement for sale, not a sale. Now, this document, if one goes by what he's saying, it is a sale deed. It's a transfer. It's not an agreement to transfer in future. It's a sale as opposed to an agreement for sale. And my lord, your lordship knows the nomenclature given to a document will not change its nature. Now, if I may take your lordship to straight away. Page 49. Sorry, page 15. I'm sorry. First clause of the contract. Now, therefore, the contract witnesses. Sellers on the date of this contract have respectively sold and transferred. So it is recording a sale. Have sold and transferred. So it's not an agreement for sale. It is a sale. Now, your lordship knows a sale may be a conditional sale, but it's nevertheless a sale deed.
Correct.
It is not an agreement for sale. Not, for example, while selling properties, it's customary earlier that one would sign first an agreement for sale, and thereafter, not the sale deed itself was executed. So there's a difference between the two stages. One is I agree to acquire on certain terms and conditions. And the second is actual transfer. This document records the actual transfer, so it will not fall within 218.
Correct.
So this is my submission on this. Then comes the second point. This was our first point in our revocation application. Second point is what is the urgency? Revoke leave granted, for not having gone into conciliation. Now, I'll be candid before your lordship. It's ultimately at your lordship's discretion. Fact is that your lordship has not exercised discretion. My learned friend relies on a judgment of our division bench which says that, look, once not granted should not be revoked. Now, that is distinguished by our court in several matters. I can distinguish it in three quick ways. What that learned judge has not actually said is, look, two judges firstly in that bench. Number one, the learned judge says if one judge has granted it, then it's not proper for another judge to revoke it. That's one. The other learned judge has said that, look, it can be revoked in the division bench. And Justice Moshumi Bhattacharya in that Admiralty matter has also distinguished it, saying that the learned division bench did not have the opportunity to consider the Supreme Court judgment in Patil. So therefore, after Patil, the position is changed. That's what this judgment says. But at the end of the day, it's your lordship's discretion. I can only point out this. I'll give your lordship the para number also. Please give me a moment. Now, please see from para 42 onwards, of 42 onwards, para 42 says that 12A is meant to be a compulsory provision. Then 43 in party law automation, the Supreme Court viewed 12A is more than a mere procedural provision and further opined that the right to institute the suit would fructify only when the precondition under 12A is fulfilled. Supreme Court, in fact, declared 12A of the Commercial Courts Act to be mandatory and held that any suit instituted in violation of the mandate must be visited with rejection of the plaintiff under Order 7 Rule 11. The issue, so Order 7 Rule 11, there can be a rejection definitely. Yeah. So the issue before the division bench in Gavril, which is not the judgment relied on by my learned friend, was whether the first court was right in granting leave to the appellant for dispensation of 12A or whether the plaintiff should have been compelled to invoke mediation before filing of the suit. Judgment, however, does not consider party automation. Correct. The view expressed by the Supreme Court in Yamini Manohar would also bind this court in the construction of 12A. Same may be said with regard to Ramesh Company and Imperial Tubes, etc. And what your lordship will find, last three lines, the court has gave emphasis on pleadings made in the plaint for making out a case of urgency. Defendants applicant was allowed.
If you have pleaded and court is of the view that there is an urgency to tell it.
Yes, but what it does is revokes leave in this case. What I'm saying is, if there is no urgency, if the power to grant it is there, the power to revoke is also there. That's all. So this is done after considering the judgment my learned friend cited, Gabriel. After considering it, the learned judge says no. That Supreme Court says there's a power under Order 7 Rule 11 to reject the plaint, and I can do so, and the defendant's application was allowed on this basis. Because the issue in para 27 was whether the court has any power to revoke. This is not the same argument as my learned friend makes. This is not considered and rejected. That's it. Don't say it.
Yes.
Now, my lord, on this, I don't think any judgments are necessary. My last point before I conclude, which is this. Now, my lord, in deciding this point of urgency, what is to be looked at? Is it to be the plaint, or can your lordship look at circumstances outside it? Now, my lord, my understanding, based on all these judgments, we can analyze judgments from across the courts, but it seems to be that the majority view seems to be that it must be based on the pleading of urgency in the plaint. Now, in this question, that's what Supreme Court says, not in that Yamini Now, in this case, not just only have a look at the pleading. What is there? Paradable. Now, my lord, the plain, lord, the lordship comes to the pleadings with regard to urgency or getting leave. Please turn to para 36, which is at page 39.
Yes.
This is the only paragraph. Plaintiffs intend to file an application praying for urgent interim relief. Therefore, it is impossible to exercise remedy of principle. Under such circumstances, leave should be obtained, and that is all that there is. Now, not what these judgments have said, not a plaintiff, not may I just take your lordship back into the judgment. My learned friend has showed, not that Yamini Manohar. My learned friend had cited that. I'll just distinguish it. Now, Lord, what is to be avoided? Not that's what your lordship has to see. Not to say it is the plaintiff's call. Not he says, I intend to file an application. Is that good enough? This is the point before your lordship. The point is not if it is meant to not surmount the law, get around the law, then your lordship will not. Now, Lord, here please see para 4 of party, Lord, where party automation is quoted. But para 100 is quoted at para 4. But I don't know whether your lordship has the same copy. But para 4 begins with this quote in party law automation.
No, para 4.
Oh. I'm sorry, Milord.
That is para 3.
I see. Milord, so Milord, party law automation is quoted, Milord, para 100. And if your lordship goes about 4 lines, Milord, from the top of that quotation, Milord, sentence beginning, other aspect raised about the word contemplate is that there can be attempts to bypass the statutory mediation under 12A by contending that the plaintiff is contemplating urgent interim relief, which in reality is found to be without basis. So, Milord, this is what your lordship really has to see. Now, at the bottom of that page, Milord, or rather of that quotation, your lordship will find the lines. In fact, in the fact of the cases, admittedly, there is no urgent interim relief contemplated in the plaintiff's question. Now, para 6.
Yes.
In the present case, it's an accepted fact that an urgent interim relief has been prayed for, and the contention that the plaintiff contemplates urgent interim relief is satisfied. This is what my learned friend was relying on. Now, my lord, please, Lord, then Lord, come to Lord, the view of the Bombay High Court in Kolchan Jogani.
Yes.
In my considered view, the proper course would be to assess whether there are any elements which prima facie indicate that the suit may contemplate an urgent interim relief, irrespective of whether the plaintiff actually succeeds or not. In a worst case scenario, where an application for interim relief is presented without there being any justification, whether for the same to simply overcome a bar under 12A, court may be just justified in recording a finding that the suit in effect does not contemplate any urgent relief, and the institution of the suit would be in the teeth of 12A, notwithstanding a formal application. So just because there's an application doesn't stop your lordship. Then, my lord, please come to para, my lord, part of para 30, para 8, my lord, considering a Delhi High Court in the case of raw perfumery. But just after that is quoted, not in my copy, there's a para 9 beginning with we are of the opinion that when a plaint is filed,
Yes, we are of the opinion
that when a plaint is filed under the Commercial Court Act with a prayer for urgent interim relief, Commercial Court should examine the nature and subject matter of the suit, the cause of action, and the prayer for interim relief. The prayer for urgent relief should not be a disguise or mask to wriggle out and get over 12A of that. The facts on the circumstance of the case have to be considered holistically.
Yes.
And then, my lord, your lordship could also see para 10. Having stated so, it is difficult to agree with the proposition that the plaintiff has the absolute choice and the right to paralyze 12A by making a prayer for urgent interim relief. So, my lord, just because I make that prayer is not good enough. Camouflage and disguise and guise to bypass the statutory mandate of the pre-litigation mediation should be checked and checked when deception and falsity is apparent or established. The proposition that commercial courts do have a role, although a limited one, should be accepted. Otherwise, it would be up the plaintiff alone to decide whether to resort to the procedure. An absolute and unfettered right approach is not justified if pre-institution mediation under 12A is mandatory, as held by the court in Patil. So, my lord, this is what it held. I don't see how it helps my learned friend at all. But it simply says your lordship has the right to examine it. In the facts of our case, there's nothing in the plaint, and the law seems to indicate, look at the plaint.
Altogether, what is the Patil automation stated?
Absolutely, my lord. Absolutely. And, my lord, last thing, my lord, 5 seconds. There are a large number of documents here suppressed. I'll disclose it in affidavits. No point, my lord, disturbing your lordship any further. I've crossed lunchtime also, but not point of suppression is there. I indicate. My lord, I've showed your lordship in the letter. He refers to a memorandum of understanding, not disclosed. He has not disclosed the fact, my lord, that his directors are still continuing to rule there. I will show those documents. There are messages exchanged between parties. I'll bring when I file my affidavit, not on merits. But today, my lord, my prayers, my lord, firstly, my lord, please consider grant of revocation of leave, and my lord, also, my lord, otherwise, if your lordship feels that there is jurisdiction, no case has been made out for grant of, my lord, any order of attachment or injunction, my lord.
So suffering for the plaintiff, so suffering for the defendant. Counsel for the defendant has concluded his argument with regard to grant of ad interim injunction and for revocation of leave. Counsel, due to paucity of time, hearing could not be revocation of leave. Due to paucity of time, counsel for the plaintiff could not reply the same. This is the matter on Monday 1 बजे खाली है.
But instead of Monday, can it be on Tuesday if I can come back?
Tuesday, देखो.
Tuesday, lordship takes up these matters.
1 p.m. How much? Half an hour enough?
Yes, yes.
On 9th, 6th August at 1 p.m.
Lordship. Lord, on a lighter note, my lord, Mr. Bachawat had started saying I had taken 1.5 hours. I shouldn't be entitled to interim order.
Yes.
He has taken 2 days, my lord.
That's
2 days and cited 20 decisions.
That's why the court has asked Mr. Bachawat whether it is a ad interim or
I
total.
submit that this is the precise reason, my lord, because 10 days have passed since I moved it, my lord. I should be protected with an ad interim order. He is shy of filing affidavits. Citation.
How, not as advocates, not we can both treat the same factors to our benefit.
Yes, thank you. Yes.
Item number 52. I'm sorry.
40 lordship was specially fixed, but the time is not printed.
40?
40 was 1 p.m. I mean, that fell from lordship.
52.
That's not printed.
What is the 40?
40.
Yes.
So this is this matter, I think, is left, shouldn't have come. Actually, it was over. The respondent filed the written notes. Now, if I would take just 2 minutes, literally 2 minutes.
Yes.
So our written notes are filed. Both the parties have filed. I'll just
respondents have filed the written notes.
Yes.
Yes. Only your replies.
My reply, I'll take 2 minutes. Namalas here. Written
the 40 file.
Actually, 52 was fixed as at 1 p.m.
The 42. It is a written submission of the respondent. You also filed. Yes.
Lordship, I'll just trouble you with just 2 small passages in 2 documents. Now, this is the respondent's written submission Now, kindly come to paragraph 5. Now, perhaps the respondent is saying, please remand. And that's what it categorically.
Yes.
Paragraph 5, the previous paras gives the dates and then said thereafter the amended specification is examined and investigated like in the manner it's copied from section 13.3.
Correct.
Now, if such thing happens, law is laid down and judgments are also part of my written submission that SCR must be issued. Okay. That's the mandate of law. There's no option. So the SCR has to be issued, and he categorically says major objections conveyed through hearing notice were lack of, so even new objections were raised in the hearing notice, apart from that. Now, here, Malaj, if I trouble you with my written submissions, at page page 20 of my written submission.
Yes.
So there are two judgments which are referred to, and copies are also attached with this note. Britannia and Oyster. And Malaj, if kindly turn to page my concluding paragraph in my note, where I have made a prayer that what should be the direction and what
page.
I'll just give the page 24. So unless these are specifically indicated, Malaj,
yes,
and this case deserves a remand. I mean, Lordship
on
has
the
seen
basis of
on the basis of it going
Yes,
up and down and kind of a fishing expedition by the authorities. And here I would like to just make an additional prayer because he's admitted. Now, when it comes to amendments, Lordship may kindly add that he should consider the amended claims, which he has said in his note that amendment claims are filed on 2 occasions. Just merely that.
Yes, that's a
full
item number 52.
Census and suffering for the appellant, census and suffering for the respondent. Both the parties have filed their written notes of argument. CA. Yes. Give the fixed matter. What 1 PM matter? What is the matter? Yes.
My suit.
What is the urgency?
Urgency. My witness was there. It was a ex parte suit. The
undefended argument.
Yes, it was. So I can come back on the other day also.
No, have you given the written notes?
No,
not
I did
prepared.
not argue at the first day. That's why I don't want to.
No, it is undefended, no?
Undefended.
Yes.
But should I bring a written notes of argument?
You do one thing, you file the written notes of argument.
My lord. And then, my lord, fixing it one day. But just one document I will show and I'll bring the written notes of argument. My lord kindly takes the brief of documents, judge's brief of documents, page 43. Your lordship will recall this is a defamation matter where, my lord, the defendants have published this defamatory article at page 42. Translation is at page 43.
42.
42 is the actual publication. I have specifically marked the entire, my lord, newspaper exhibit. My lord kindly takes the official translation at page 43.
Yes.
Exhibit D. Public are hereby informed that Shri Sanjay Counsel, plaintiff, this is the plaintiff number 2, and others have constructed a pakka building by filling up a pond, dag number such and such, at premises number such and such. Under this situation, Shri Murari Mohan Kormuka, the defendants and others, who are the co-sharer owner of the said pond, by initiating title suit in the Court of the Learned Civil Judge Junior Division, Salt Lake, have obtained an order of injunction and the said injunction order is continuing. Under this situation at present, the said Shri Sanjay Counsel and others or their associate organization, by violating, kindly marks the word, violating the order of injunction issued by the aforesaid court, which is still in force, have started to sell and dispose of the flat constructed illegally in the said manner, which is illegal. Under this situation, if anyone wants to sell or purchase the said flat, enter into transaction, then all the legal liability and responsibility will be entirely on them.
So, well, two things. One, he says, I am violating the order of injunction. And, my lord, I have constructed illegally. Two specific, my lord, statements made. Now, my lord kindly takes the order which he is referring to. The order at page 40, which he has got, which the defendants have got.
Page 40.
Page 40, Exhibit C, which the
Yes.
defendants have got, which the defendants are talking about.
Yes.
Kindly see the ordering portion. That the temporary injunction petition filed by the plaintiff is allowed on ad interim basis. The defendants, that is my clients, plaintiff, are hereby restrained from changing the nature and character of B schedule property by way of encroaching southwestern bank, that is the scheduled property whatsoever, till 20th April 2021. So only not to encroach the southwestern bank. And he says there is an order of injunction and the order of injunction from selling, and that I have illegally sold.
Yeah.
So this is absolutely defamatory, per se defamatory, on the face of defamatory. And since I have illegal construction, no court has declared that the construction is illegal. No court has injuncted me from selling or transferring the property. But this is per se, on the face of it, defamatory. I have pleaded for special damages and general damages. I will show your lordship. Now I have also produced, my lord, a supplementary paper book. My lord, a supplementary paper book was asked by your lordship to be filed, containing those two documents which were exhibited on the last occasion. Original that has already been filed with your lordship. Kindly see those two documents, which will show that flat owners have already, my lord, sought for cancellation pursuant to this defamatory, my lord, publication. My lord, I have got case laws which will show. I will show on the last occasion. I'll include next occasion. I'll include in my notes that in case of a general, my lord, damages, in case of a defamation suit, I need not even prove, my lord, any specific damage suffered. If I can show that they are per se defamatory, it's the court's, my lord, duty, my lord, to award damages. And to the extent what damages will be allowed, my lord, I will show you.
Okay.
I will come. My lord, any day, your lordship. If there's no urgency as such, my lord, your lordship can fix it.
Since appearing for the plaintiff, appearing for the plaintiff, the case fixed today for argument. Counsel for the plaintiff has argued the matter at 10, but due to paucity of time, argument could not be completed. Fix, give the date. (14th) at 1 p.m.
14th.
Plaintiff is also directed to file the written notes.
So the fee-earning document of Mr. Fee-earning document of
One indulgence, my lord. Item number 8, the lordship passed it over, my lord. My learned friend is here, my lord, appearing for the respondent number
I have
1.
specific
Good
instructions.
time you has come. Yes.
Your Lordship, in this matter, I have a specific instruction that the subject trademark is not in use since last 20 years. So we are withdrawing the application. We have also filed a letter which is not in a proper format. We'll serve
Who is
them.
the
a
appellant? My lord, I am for the applicant, my lord. I have challenged his trademark application, which he now intends to withdraw, my lord. So, lordship.
So come with the settlement, or you give, or come with
My
an
lord, there is-
affidavit.
My lord,
Come with an
yes.
affidavit.
Your Lordship, it's just a normal application which we are withdrawing. So we'll file one affidavit with the withdrawal petition.
That's why. Come with an affidavit. How soon?
Within 1 week.
My lord, next Friday, my lord.
As per the item number 8. So and so appearing for the applicant, so and so appearing for the respondent, police counsel for the respondent, prays for a week time to file affidavit. Let us say that file within a week. Release the matter on 13th of August 2020.
Grateful, my lord.
I believe there is a resolution at 3:30, my lord. Can we move it slightly earlier?
I don't think all the fixed matters are there.
Then, my lord, can we come back at 3:30 itself?
See, if time permit, if any matter will be adjourned, I will take.
No, otherwise we'll move it at 3:30, my lord.
Yes.
I appear with defendant number 2 and 3.
No.
My name is Arpit Kuteta.
ঠিক আছে?
Cross, huh?
May. Witness, kindly tell my lord as to when and from where you have completed your course.
My lord, I have graduated from IIT Bombay in Bachelor of Technology, Civil Engineering. Civil Engineering. I have graduated in the year 2015.
So, what was your first job after graduating in 2015?
My lord, from campus placement, I was placed in a consulting company, Hay Group Limited. Hay Group, Hay.
So, when have you joined railways?
My lord, I joined railways on 30th of July 2018 after clearing engineering services examination 2017.
Kindly come to your evidence, question number 56. সম্ভবত 1 মিনিট। Just a moment. ভুল হচ্ছে 1 মিনিট। আরে কোশ্চেনটা কোথাও জয়েনিং এর কালকে সাজিয়েছি উল্টো পাল্টা করে দিয়েছে এসে। ইয়েস। আপনাদের কি রোজ নম্বরিং হয় এভরিডে 1 2 3 4 কারণ আমার কাছে দুটো 58 কোশ্চেন আছে দু রকম, ওই জন্য আই গট কনফিউজড। 27 জুলাই দ্যাট ইজ 58 না কন্টিনিউয়াস হচ্ছে না। I have 258, that's the reason I got confused because 27 July, yes. 3rd July there is 58, 27 July there is also 58.
How it can be? So how then the number continues?
Oh, I'm sorry, my fault. কালকে অশিক্ষিত গুলোকে ঢোকাতে দিয়েছি। Question number 58. 58, 58. Kindly see and tell my lord, what have you deposed before this honorable court on July 3, 2024?
So the date.
July 3, 2024. Question number 58.
My lord, it was asked that how will you say that this has been signed by Chief Bridge Engineer? So in reply, I had said that I have joined service of Indian Railway, and
I said that I joined Indian Railway
in 2017. Personally, I do not know Shri S.B. Ninave. But what I can do is, I can, after consulting my headquarter, if Shri S.B. Ninave's signature, can be found as an approved signature, then I can ask for that.
Do you know when the tender was floated in the involved in this concerned suit?
Yes, my lord.
Kindly tell my lord the date when the tender was floated.
My lord, it was floated in from the records when I can recall is near about 23rd of February 2010.
So I take it that during that tenure you were not employed with the railways.
No, my lord.
Where was your first posting after you joined railways?
My lord, my first posting after I completed my training in Indian Railways was in Nagpur Division, Tumsar Road Subdivision as Tumsar Road Subdivision, TUMSAR Subdivision as Assistant Divisional Engineer in the year February 2020.
When have you joined the Jharsuguda division of railways?
My lord, I was posted as Executive Engineer, Jharsuguda, in October of 2023.
Kindly come to your question number 12 of your deposition dated April 12, 2024. So according to you, it was, have you gone through the questions and answers? So according to you, it was whose obligation to carry out the geotechnical survey or investigation?
My lord, as per contractual items, it was the item for geotechnical survey was present in the contract. But since railways had already conducted the geotechnical survey beforehand, the report of the same was given to the contractor.
I repeat my question. It was whose obligation to carry out the geotechnical report under the contract?
My lord, it is not the question of obligation. It is the, as per contract, and various conditions mentioned therein regarding change of variation in kind of work to be done. The contractor has to do the work after instruction from railway is received.
Questions repeated. Question repeated. Kindly answer my question. Don't give evasive reply. It was whose obligation under the contract to carry out the investigation survey?
My lord, I'll keep my answer as geotechnical survey would have been done by contractor if railways had instructed the contractor.
So I take it that this is your evidence that it is not the until and unless railways give instruction, the contractor will not go forward and carry out the geotechnical investigation.
Yes, my lord.
একটু এক্সিবিট ডিটা দেখান তো। Judge's brief, page 260. Plain list of documents. Plaintiff Judge's brief, volume 1, page 260. আচ্ছা দিয়েছেন? Kindly come to Schedule A. And tell my lord that where it is written that until unless railway give instruction, the contractor will not carry out with the geotechnical investigation. Kindly go through it and tell my lord.
My lord, the condition regarding instruction from railway to start the work are normally part of general conditions and terms and conditions of the contract. It is not mentioned in the schedule specifically.
So what has been mentioned in the schedule? That who has to carry out with the geotechnical investigation?
My lord, there is nothing mentioned in the schedule as to who has to carry out the geotechnical investigation.
You again go through the tender document and tell my lord that what has been mentioned that who has to carry out the geotechnical investigation. And where it is written that railway will give in the instruction, then that the railway will give instruction and then the contractor will carry out the geotechnical investigation. Not prior to that.
ये मानो तो ये तो 2016 का है ना, हम लोग हमारा ट्रिब्यूनेशन। हाँ तो हमारा तो वो कोर्ट में जाएगा, डेट फिक्स करेगा या नहीं करेगा, और ये अमेंडमेंट पिछले हुआ वो कोर्ट है, हम लोग नहीं। हाँ 2016 का है ना, तो हम लोग का डिटर्मिनेशन।
My lord, can I have the copy of general conditions of contract 2001?
Give the general as per the request of the witness.
No.
General condition of the contract has handed over.
ওই মনে হয় বাঁধানো বইটার কথা বলছে।
Which is the exhibit?
একটা বই দিয়েছিল, একটা বাঁধানো বই দিয়েছিল, বাইন্ডিং বুক।
It was a book, hard, proper book.
এই হ্যাঁ লিস্ট অফ এক্সিবিট আছে। হ্যাঁ
My lord, on page number 30 of General Conditions of Contract.
Which clause?
Clause 19, subclause 2, regarding commencement of works. It clearly states the contractor shall commence the works within 15 days after the receipt by him of an order in writing. After the receipt by him of an order in writing to this effect from the engineer, and shall proceed with the same with due expedition and without delay.
So where does it say that the geotechnical investigation had to be done by the railway, number one, and the contractor cannot proceed with the geotechnical investigation until and unless the railway gives the assent?
My lord, with regards to first question, as I can recall, it is a railway board policy that before finalizing the tender, the geotechnical investigation should be completed. According to that policy, railways had conducted the geotechnical investigation.
Which,
secondly, as mentioned in clause 19, subclause 2, it clearly states that any work which has to be started, the work order shall be given in writing from engineer before starting of the work by contractor.
Which policy are you talking about of railways? Have you disclosed in suit?
My lord, I do not remember the exact policy number because there are a lot of policies and guidelines. If required, I can produce it afterwards.
Have you disclosed anything in the suit? My question is very clear.
Whether that policy has been disclosed prior in this matter or not? Yes or no? Or you know or you do not know?
I do not know about.
So when the railways carried out the geotechnical investigation, what happened to Schedule A and the cost mentioned therein, and also the scope and purview of the contract?
My lord, in the agreement, contract agreement, special conditions of the contract, chapter 6, agreemental conditions, clause 1.32.2, 1.32.2, power of modifications of contract. It clearly states that engineer on behalf of the railway shall be entitled to order in writing to enlarge or extend, diminish or reduce the works, or make any alterations in their design, character, position, site, quantities, dimensions, or in the method of their execution, or in the combination and use of materials for the execution thereof, or to order any additional works to be done or any works not to be done.
Additional works to be done.
To be done or any works not to be done. and the contractor will not be entitled to any compensation for any increase or reduction in the quantities of work, but will be paid only for the actual amount of work done.
I am repeating my question that what happened to Schedule A?
My lord, clause 1.32.2 clearly answers that question.
I am repeating my question that what happened to Schedule A after the work was done?
This already answered.
After the work was done, not by the contractor, and it was done by the railways. Apropos this contract.
My lord, since that work was not done by Rahi GPT, they were not paid for the same also.
এই তো তিনবার জিজ্ঞেস করতে হবে। Kindly comes to your question number 15 of your deposition dated 12th April. So, according to you, there was no prohibition on the part of the contractor to conduct the geotechnical survey
on their own.
On their own. So,
answer on their own.
You have just now deposed that the contractor will have to wait for the assent of the railways. So why you have deposed in question number 15 that there was no prohibition?
My lord, there was no prohibition for the contractor to conduct his own geotechnical investigation at his own cost. For that work, railway would not pay the contractor, as railway had already conducted their own geotechnical report and same own geotechnical investigation, and the same was also handed over to the contractor.
When have you handed over the complete site, work site, to the plaintiff or the contractor?
My lord, as I had went through the facts of the cases thoroughly, from that I have gathered that on date 27th of August 2010, the contractor's representatives first visited the railway office, wherein they were given the subsoil exploration report by railways, and also on after issual of letter of acceptance by railway in July of 2010, it is on communication of that letter, it is deemed that site has been handed over to the contractor.
When have you actually handed over the site to the contractor?
My lord, in the records present in the files, I have not found any written record as to on this date site has been handed over, but that communication regarding 27th of August 2010, wherein subsoil exploration report was given, and subsequent letter of the contractor that they have received the same and started the designing process based on that report. I consider that at that time site is considered to be handed over.
So which part of the contract agreement gives the authority to railway to carry out the soil investigation report on its own? Investigation or geotechnical investigation report on its own?
My lord, since the geotechnical investigation was conducted prior to the finalization of the contract, in my understanding, there would be no any conditions regarding, in particular with geotechnical investigation, which gives railway the right to conduct geotechnical investigation in this extant contract.
Kindly go through the contract document and show the clause that authorizes railway to carry out the geotechnical investigation. Dated September to 2011.
My lord, since contract was awarded after railway had conducted its own geotechnical investigation, in my opinion, there will be no specific clause in the contract as authorizing railway to conduct geotechnical investigation on its own. But as highlighted in my previous answer, clause 1.32.2 regarding scope of work and variation of work, it clearly states that railway can increase, add, or reduce the works to be done under the contract.
So I take it that this is your evidence that there is no such clause in the contract which can authorize the railway to carry out the geotechnical investigation. Yes or no?
Not specifically.
Through court. The geotechnical investigation which was carried out by the department prior to awarding the work, whether that geotechnical investigation incorporated in the agreement or the tender document.
This particular geotechnical investigation, no.
No. So whether the geotechnical report was forwarded to the contractor?
Yes, my lord.
When it was forwarded?
As per record, on 27th of August 2010, after award of letter of acceptance.
Whether the contractor has given any objection to this geotechnical report?
My lord, they had replied, I think, the very next or within 1 to 2 days, that they were expecting that they had to do geotechnical report. But since Railways has given them the report and they have received the report, so now they are proceeding with design of foundation based on the report provided by Railways.
Yes, now continue.
Now, according to you, the geotechnical investigation report was already conducted and done prior to the tender was floated.
Yes, it is admitted.
My lord, as far as I know, because from the files available with me, I can say without before awarding the tender, the geotechnical report was with Railways.
Kindly come to page 307, plaintiff's volume 1. Exhibit ta dekh. What was এটি এক্সিবিট কত আছে? এইটি জিওটেকনিক্যাল রিপোর্টটা এই 307
এক্সিবিট করনি,
সামনের দিকে থাকবে, এটা মাঝের পাতা।
Yeah. See the list whether the original is exhibited. Or it is from the JVD. PD? It's 3 years. PD 32. V. Exhibit V.
Oblige. What is the, kindly see serial number 7. Internal page 15 of that document. তলা দিয়ে নম্বর আছে দেখ আচ্ছা পেজ 307 টা দেখা and tell my lord what was the type of foundation that was proposed by railways in the report.
My lord, the type of foundation which was recommended in this subsoil exploration report by the agency conducting the subsoil exploration is well foundations.
So did the plaintiff ever written to the railways that the well foundation was not the proper methodology to carry out the job in respect of the said site?
My lord, since the question has been asked ever, so as far as I have noticed all the records, from the award of LOA, letter of acceptance, till the original completion period, the records which I have gone through, nowhere have I found where plaintiff has written that well foundation is not the proper methodology for this work.
So according to you, why was the value of the contract increased from time to time of the same site when the railways floated tenders in respect of the said sites? Why the value was increased?
My lord, in my understanding, since this initial first tender was floated in 2010 and subsequent tenders were floated in 2014 or thereafter. So due to normal inflation and due to since every year many contracts are being finalized by railway, the last accepted rates keep on changing, or they may increase or decrease as per
the market rate,
as per inflation. So the value of the contracts may also increase even if same items are considered. And if in new contracts, since it is a new contract, some additional items are added. If some additional items are added, then their costs can add up to increase with comparison to previous tender.
So according to you, what is the normal percentage of increment from one tender to another tender due to passage of time that is being given by railways?
My lord, there is no as such specific normal increase that every year this much increase will take place. It totally depends on last accepted rates.
The defendants documented 462 টা একবার যেটা মোটা যেটা আছে আমাদের কত এটা কোথায় আছে এটা আমাদের বলে 462 What is the approximate value given by the railways in respect of the same site for the balance work to be done?
My lord, this tender is not for the balance work to be done. This tender is for construction of bridge 182 on a different alignment. since the work which was being done by plaintiff was left incomplete, and the subsequent tender for balance work, there were no offers received by railway. So railway had to change the alignment and float a new tender at a different alignment.
What was the nature of change in the alignment?
My lord, the line which was crossing the river from particular place, it was shifted laterally to a different place.
So what methodology that railway proposed this time while floating this tender in 2015 in respect of the self-same site?
My lord, in this new tender at new alignment, pile methodology of pile foundation was adopted.
What was the reason for changing of the entire alignment methodology from foundation to piling by railways?
My lord, this work of third line from Champa to Jharsuguda, Champa to Jharsuguda, was a very critical project for railways with respect to evacuation of coal, evacuation
of coal
from the mines towards various thermal power plants.
Power plants
In India, which ultimately ensures proper generation of energy. Since it was expected that the initial work would be completed in 2012 as per original completion time, and due to failure of the plaintiff to carry out the work, and subsequent tender for balance work received no responses. This tender was done by changing the alignment and methodology of foundation as a measure of, as a response in like urgent response, because the work was needed to be completed at the earliest. To prevent any further losses to railway from ongoing congestion on the available two lines, and to mitigate any public inconvenience at the earliest.
So I take it this is your evidence that there was coal in that part of the site.
My lord, that part of the site, as per geotechnical report, you are referring to which one, the new one or the old one? Which site?
The last tender.
Second tender.
Second tender or third tender.
This tender.
This tender.
This tender. My lord, as per documents, I have not gone through the geotechnical, as per the documents available, I have not gone through the geotechnical report at this particular site. So, I'm
of
unable.
this particular site, referring to which tender number, subsequent tender dated
2015 one. This
Subsequent to tender dated.
My lord, it is dated 16th of September 2015.
ওটা থাক ওখানে, এক্সিবিট আইটা দিন।
Can you say what was the reason for changing the site
the
and with regard to the technicality, earlier the geotechnical, now it is the pile works. Why it has been changed?
My lord, firstly, when the agreement for agreement with the plaintiff was terminated, as per my knowledge, another tender was called for completing the balance work at the same site. The railways received no responses from any parties for that tender. So in my understanding, it must have been approvals must have been taken to change the site so that work can be started and third line can be completed.
So the court can take into consideration that the site was not suitable for the contractor to execute the work. That's why the contractors are not participated in the second tender for the same site.
My lord, I cannot say that why contractors had not participated in the tender for balance work, but in my working, in my short working, which I've seen is normally for short working in railways, what I have seen is normally at a major site, if works have been left incomplete by
major site, if the work has been left incomplete,
then there are very less takers for that work again.
Yes.
এক্সিবিট আইটা দিন। ঠিক আছে, থাক ওটা থাক। So I put it to you, I'll come to that. I put it to you that it was not possible for any of the contractors to carry out with this project with the same methodology.
No, my lord. Anyways, railways had floated the tender for balance work to be completed at the same site. So it was possible to complete the work at that site.
So did anyone participated when the second tender was floated?
No, my lord, as also stated previously.
No.
Now you see exhibit I and see the scope of work in exhibit I. This is exhibit I. And the scope of work at page 462, that is the earlier document, that the third tender that you saw last question. 462. Are the scopes similar?
My lord, the name of work is similar, but the alignment was changed as is evident on the site as on date.
Where it is written that the alignment, no, means it's similar.
The name of work
is similar, alignment is changed.
Because name of the work is same.
So what was the methodology recommended by railways in this tender dated 23rd of June 2014? Second tender?
My lord, since this tender was for completing the leftover balance work, the same methodology at the same site was incorporated in this tender.
What do you mean by same methodology?
Well foundations.
Well found.
Well founded.
So I take it that as you have got no tenderer, you have changed the alignment from on the methodology from well foundation to piling.
My lord, since the alignment was changed to a different location, new geotechnical investigation must have been done. And whatever would have been recommended therein would have been incorporated in the new tender.
Have you produced any document to that effect before this honorable court?
No, my lord.
So what was the necessity for changing the location?
My lord, since there were no bidders for the balance work,
No bidders come forward for the balance work.
and since this project was very important as the total area in Chhattisgarh and Odisha are primarily the coal mining areas from where coal is evacuated majorly by railways to the thermal power plants for power generation. The criticality and urgency of the work required that it be completed at the earliest, hence the location was changed.
Have you disclosed any document pertaining to the changing of location before this honorable court?
No, my lord.
So I take it that there was coal underneath the soil.
On which location?
You just deposed that the coal evacuation. So I take it
Coal
that there was.
evacuation in Chhattisgarh and Odisha.
So I
That is
take
a
it that there was
huge area.
coal or
That is
not.
a huge area, my lord. On that particular site, only geotechnical investigation can disclose.
Sir, you have to either say yes or no, then you can answer. So I take it that there was coal underneath the soil. Yes or no?
At the location, at the new location, I am not aware. At the old location, yes.
So I take it that you don't know what was there underneath the soil and you are giving evidence from your own understanding without going into the records.
My lord, from the records of the extent agreement, there is nothing mentioned as such. Learned counsel is asking. From railway records, I have seen internal records where it was mentioned that methodology has been changed due to change in location.
So have you disclosed any such document?
No, well.
You can stop here and come back.
Got the flow.
Good time to stop today. Good time to stop today.
Okay. Please step down. Senses and suffering for the plaintiff. Senses and suffering for the defendant. Dependent witness is present. Cross-examination is started. But due to paucity of time, cross-examination could not be completed. Accordingly, process step. Please the matters. Any date is fixed? No.
No, my lord will give any 2 dates.
How much time will take for the? It will take time.
It will take a little time. But my lord, I'll want to continue because otherwise.
18 September at 3 p.m. 19 September at 2 p.m.
18 September 3 p.m. 19 September
2 p.m.
18 to 18 or 19 একদিন 2 p.m. একদিন 3 p.m. Obliged.
I think my learned friend will complete. That's why I fixed 2 dates. In two days.
স্যার আপনি 7 দিন নিলেন, আমি একদিনে করে দেবো? একটু আসুন, ঘুরুক, কলকাতা ঘুরুক। হ্যাঁ, না তো ভেবে ভেবে দিচ্ছে।
Obliged.
Partial list. Presentation of trade, item number 50. कोई नहीं है कभी।
15 बोल रहे हैं। Actually, this is my suit.
Yes.
Actually, this is my suit. Section 12 has been complied with in the mediation proceeding. Other side did not turn up. The mediation proceeding has failed. Lordship, the relevant pleading is at para 15, my lord. And then
Why order to rule 2?
Lordship, I prayed for order to rule 2.
Why?
Lordship, because this is a company which has given some loan and the money has not been given back to us. So we crave leave to file for additional damages, if any.
Additional?
Damages.
Why additional damages? No, because it's a lent in advance.
Lordship?
Why you are claiming the damages? What paragraph?
Lordship, because there is an amount of 71 lakh which was due from them, the defendants, that is the principal amount. With interest, this has accumulated to around 5 crores.
Correct.
Lordship. So since that amount was stuck with them, any additional consequential losses that may have arisen, Lordship.
What consequential arose, sir? Because this is a lent in advance amount.
Yes.
Correct. You
Yes.
have paid the amount. They have not returned the amount.
They have not.
So you have paid for the return of the money.
Along with interest.
Along with the interest. So further damages what?
Anything that might have happened. Very well, Lordship.
And why clause 12?
Lordship, clause 12, because the registered office of the plaintiff is situated outside the jurisdiction of this honorable court. The corporate office and the defendant's office are within the jurisdiction.
Mediation report?
Mediation report, Lordship, it's at page.
Why commercial matter? Why commercial suit?
Lordship, this arises out of mercantile agreements and agreements.
There's an agreement entered by business agreement.
No, this is a loan agreement that was given in a commercial transaction.
Where is the loan agreement?
Lordship, there is no loan agreement that was given pursuant to a board resolution, Lordship.
Then how it can be?
Lordship, the relevant pleading, Lordship, I'll indicate.
Might be pleading, but you have to satisfy which clause it will come under the commercial act, sir.
Clause 2C, not regular trading.
Simple loan, interest.
Lordship,
You might be you are carrying the company, but it is not the business transaction.
Lordship, can it be made not to? I will come back on the next day and satisfy my lord on why it should be under the Commercial Codes Act.
Because you have claimed with regard to the
Lordship,
confirmation.
Lordship makes it not to. I will come back on the next day and satisfy my lord.
Not today.
I appear for the plaintiff, your lordship, in this, your lordship. I am being led by Mr. Jishnu Chaudhary, your lordship. I presume he's online, your lordship.
Item 16.
16, your lordship.
Yes. What is the matter about?
Your lordship, this is a suit, your lordship, for declaration and injunction, your lordship.
Declaration and injunction.
Declaration.
Commercial suit.
Commercial suit, your lordship.
What is the
your lordship? This arises out of an agreement, your lordship, that has been entered into the party into between the parties, your lordship. Initially, your lordship, loans were granted, your lordship, in relation to businesses that were to be conducted by the plaintiff, your lordship. Thereafter, a settlement agreement was entered into, your lordship. Your lordship,
the settlement agreement.
Your lordship will find us. Your lordship, this was through WhatsApp communications, your lordship. Now, your lordship will kindly grant us a day, your lordship. I'm being led by Mr. Jishnu Chaudhary, your lordship. He'll present the plaint, your lordship.
Not today.
Great.
Item number 70. 70.
I'm for the official liquor opposing.
Have you received the amended plaint?
No, not yet, ma'am.
Who is for the petitioner, plaintiff?
Mr. Basu.
Huh?
Mr. Basu, on the last occasion he appeared.
Surajit Das Gupta. Not today.
Basu. 17 to 20.
21. 21.
21 is a time limit. Not today. 21 years. 21, Mr. Saini, your lordship mentioned the matter for not today.
Not today.
No notice given when mention exporting without.
No.
I'm not intimated in matter.
Okay, you want to carry out, you carry out, no problem.
No, if you told me I'm waiting since Monday.
So henceforth, I will not take the matter without both the party will appear.
Yes.
Every day this is happening. I intimated when the matter is called. Now I have not been intimated.
Waiting here since
And
morning.
take note from today, henceforth, no mentioning without both the party present.
Yes.
No date without two party present.
Yes, please.
Please take note of the bar. The
But
court
that is-
should not
that
be
is a- that is
made
a-
embarrassment.
That is a rule of the High Court. Notice will be given to the.
Okay, this court will be henceforth will go by the High Court rules only. No leniency.
Yes.
No leniency. Nothing. As per the list, it will go. No mentioning will be allowed. No date will be fixed.
Without notice.
Come and sit whole day and take the matter. Yes.
Don't take a miss note. I am waiting.
No, not I am taking otherwise.
Yes, this morning.
I am telling to the total bar members. Henceforth, no mentioning, no fixing, nothing. List will be published accordingly. Time permits will be taken. Not time permits, go.
22.
22, your lordship, I am for the petitioner.
Yes.
And I'm for the defendant.
Capcom matter, your lordship, parties have settled, your lordship.
Yes.
Your lordship, we have, your lordship, executed, your lordship, the terms of settlement. Copy, yes, sir. Both parties' representatives have signed, your lordship, and the learned advocates have also signed, your lordship.
22.
22. Item 22, your lordship.
Census and suffering for the plaintiff, census and suffering for the defendant. The counsel for the plaintiff has filed the terms of settlement entered between the parties on 1st of August 2024, which was duly countersigned by the learned advocate for the parties. Full stop. And counsel for the respective parties submitted, the parties have settled their dispute and have entered into the terms of settlement and placed for disposal of the suit in terms of the settlement dated 1st of August 2024. This court has produced the terms of settlement entered between the parties and find that there is no impediment to accept the terms of settlement entered between the parties. Accordingly, the IP Form 13 of 2024 is disposed of in terms of settlement entered between the parties dated 1st of August 2024. The terms of settlement be made as a part of decree. IP consensus and disposal of decree.
And
interim order.
The applications be disposed of.
Consequently, all applications full stop. As the parties have settled the dispute and suit has been disposed of, interim order is vacated, and all connected applications have been disposed. Be treated as disposed.
The interim order should be merged, your lordship, because there is an injunction.
That is there. What is the decree? It will merge in the decree. So interim order cannot continue. Yes.
This is my matter.
Yes.
Commercial matter.
What is to be done?
Nothing. Only judge's brief has to be. I have prepared that, and evidence.
Your witness is present.
Yes, ma'am.
Tell that.
नहीं हिंदी।
आज पहली बार आप दवाई देने आए?
हाँ हाँ पहली बार।
मेरे साथ बोलिए, ठीक है?
हाँ जी।
हम धर्म से कह रहे हैं,
हम धर्म से कह रहे हैं
इस मुकदमे में
इस मुकद्दर इस मुकदमे में
गवाही के तौर पर
गवाही के तौर पर
हम जो कुछ भी बोलेंगे
जो कुछ भी बोलेंगे
सच बोलेंगे,
सच बोलेंगे,
सच के सिवा झूठ नहीं बोलेंगे,
सच के सिवा झूठ नहीं बोलेंगे
और कुछ नहीं छुपाएंगे।
और कुछ नहीं छुपाएंगे।
आपका नाम?
प्रदीप भीमराज का, प्रदीप कुमार भीमराज का।
स्पेलिंग
PRADIP KUMAR BHIMRAJKA।
पिताजी का नाम?
लेट मदनलाल भीमराज का, MADAN BHIMRAJKA।
आपकी उम्र?
मेरी उम्र 57।
57। क्या करते हैं आप?
मेरा बिजनेस करता हूँ।
बिजनेस। और कहाँ रहते हैं? घर का पता बताइए
40
धीरे धीरे से।
43 कैलाश बोस स्ट्रीट,
कैलाश बोस स्ट्रीट,
गोपाल भवन,
गोपाल भवन,
ब्लॉक C,
ब्लॉक C,
3rd फ्लोर,
फ्लोर
फ्लैट नंबर 323, कोलकाता 7,06,000।
7,06,000।
आप इसमें आइए,
मैं जोर से बोल दूंगा।
माइक्रोफोन में आइए आप। यस, बोलिए आप क्या बोलना चाहते हैं?
Actually, my senior is
Yes.
leading him. He just matter has been calling us. That's very clear. So he follow. I am not aware about anything about the matter. I will.
You will continue or adjourn?
I will continue, my.
Okay, okay, continue, continue.
Mr. Bhimraj ka. What is that document?
ये बोर्ड ऑफ
क्या है माइलॉर्ड को बोलिए।
ये बोर्ड ऑफ मिनट का है, जिसमें दोनों डायरेक्टर मिलके अपने को मतलब क्या केस करना है उसके बारे में बोले।
The extract of the minutes of the minutes of the board of directors meeting in which the directors sat together and decided what to be done
हाँ, मतलब केस के बारे में
about the case.
हाँ
धीरे से बोलिए, छोटा छोटा।
हाँ ठीक ठीक
कोई जल्दबाजी
ठीक।
नहीं नहीं आज कैंडिडेट विद चॉकलेट आज ही कैंडिडेट के साथ बिफोर द आपका कोर्ट में जमा कर रहे हो डॉक्यूमेंट?
हाँ 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 मैं कोर्ट में जमा किया हूँ।
यस।
आप माइक्रोफोन में बोलिए, उनको सुनना है, लिखना है। आज
वो गड़बड़ कर देते हैं ना सुनने में।
आप माइक्रोफोन में बोलिए, वो हमारा जो इंटरप्रेटर है वो बता देगा।
तो हैव यू टेंडर्ड दिस?
क्या आपने ये डॉक्यूमेंट टेंडर किया है, जमा किया है?
हाँ मैंने जमा किया है।
Yes, I have submitted this document.
हाँ, I am tendering this document.
I am tendering.
मिस्टर भीमराज का व्हाट इज दिस डॉक्यूमेंट?
Exhibit एक और इधर।
बस
ये डॉक्यूमेंट क्या है बोलिए।
ये मेमोरेंडम ऑफ अंडरस्टैंडिंग है, जो कि देवव्रत घोष और न्यूवर भिनकॉम प्राइवेट लिमिटेड के साथ में जो कैसे क्या लेन देन होगा उसके बारे में डिटेल्स बोला गया है।
This is a memorandum of
This is the memorandum of understanding
in
entered
which
between देवव्रत घोष
between Debabrata Ghosh and
न्यूवर भिनकॉम प्राइवेट लिमिटेड न्यू एवर भिनकॉम प्राइवेट लिमिटेड
Private Limited.
उनके साथ जो लेन देन हुआ, जो उसका सब डिटेल्स कैसे क्या लेन देन होगा सब डिटेल्स बोला गया है।
The transaction that has been done with them, it is written here.
Are you tendering this document?
हाँ मैंने document
How it will go? Let us say something about the document.
अभी एक मिनट पूछता हूँ एक मिनट पहले टेंडरिंग का आ जाए now this document what you have tendered now is a memorandum of understanding between whom?
वो बोल दिए हैं.
Where has it been? Where has been drafted or done?
Where has it been done? ये डॉक्यूमेंट कहाँ प्रिपेयर किया गया है?
ये डॉक्यूमेंट मेरे लॉयर ने प्रिपेयर किया था जब हम लोग पहले जो दोनों में देवव्रत घोष और न्यूवर विनकॉम का जो एग्रीमेंट हुआ था वो एग्रीमेंट MOU है.
This document was prepared by my lawyer. This is a MOU between Debabrata Ghosh and
न्यूवर विनकॉम प्राइवेट लिमिटेड.
Whose signature are they?
किसका सिग्नेचर है यहाँ पर?
इसमें मेरा सिग्नेचर है.
There is
मेरा
my
मतलब प्रदीप कुमार भीमराज का.
There is my signature in this document. Pradeep Kumar
और देवव्रत घोष.
And there is also the signature of Mr. Debabrata Ghosh.
In what capacity you have
Sign this document.
signed this document?
आपने किस बिना पर इस डॉक्यूमेंट पे साइन किया है?
मैं उस समय डायरेक्टर था. मैं डायरेक्टर की हैसियत से डॉक्यूमेंट को साइन किया.
किसका डायरेक्टर था?
न्यूवर विनकॉम प्राइवेट लिमिटेड का मैं डायरेक्टर था.
I was the director of the New Era Vincon Private Limited at that point of time, and in this respect, I signed on this document.
Do you know the signature of Debabrata Ghosh?
क्या आप मिस्टर देवव्रत घोष की सिग्नेचर को जानते हैं और पहचानते हैं?
हाँ मैं पहचानता हूँ.
Yes, I know his signature.
How do you know about his signature?
कैसे जानते हैं आप उनके सिग्नेचर को?
मैंने उनका और भी सब डॉक्यूमेंट मेरे को मिला है. सब में सिग्नेचर मैं देख लिया हूँ. सब सेम सिग्नेचर है.
I got various document which bears the signature of him. I tally the signatures and it is the same everywhere. I have tallied the signatures and it is the same everywhere.
Was it signed in your presence?
क्या उन्होंने आपकी प्रेजेंस में साइन किया था?
हाँ मेरे प्रेजेंस में साइन किया.
Yes, he signed this document in my presence.
What is the date of that?
इस डॉक्यूमेंट का डेट क्या है?
7 फरवरी 2013.
7th February 2013.
So you are tendering this?
हाँ.
So you are tendering this document? Answer is yes. Exhibit B, my lord.
Exhibit B.
Mr. Bhimraj ka. What is this next document?
What is this document? ये डॉक्यूमेंट क्या है बोलिए?
ये डॉक्यूमेंट 20 जनवरी 2017 को उन्होंने लिख के दिया था कि मैं आपको डिक्लेरेशन है. लिख के दिया था कि मैं पैसा मैं एक जो
किन्होंने लिख के दिया था?
देवव्रत घोष ने लिखा है.
20th January 2017, Debabrata Ghosh given a written declaration.
क्या मैंने जो आपसे लोन लिया हो वो लोन 15 से 30 दिन के अंदर
that he will repay the loan within 15 to 30 days.
पूरा रिफंड कर दूंगा. नहीं तो मेरा जो प्रॉपर्टी है मकान है जिसमें मैं रह रहा हूँ वो बेच के भी आपको पूरा पैसा आपको क्लियर कर दूंगा.
I will pay you the full amount if I will pay you the full amount within the stipulated time. If it needed to sell my house, I will pay you by doing that.
If needed, I will sell my house and I will return the said amount to you. To the plaintiff.
Has signed this declaration?
ये डिक्लेरेशन किसने साइन किया है?
ये देवव्रत घोष ने साइन किया है और उन
document was signed by Mr. Debabrata Ghosh.
और
was it signed before you, in your presence and before you?
क्या ये डॉक्यूमेंट उन्होंने आपके सामने साइन किया था?
हाँ मेरे सामने में साइन किया.
Yes, he signed on this document in my presence.
Do you know his signature?
क्या आप उनकी सिग्नेचर को पहचानते हैं?
हाँ, मैंने पहचानता हूँ उनकी
And
सिग्नेचर।
who else has
I
signed
know
that?
his signature. और
एक और है।
किसने यहाँ पर साइन किया है?
विटनेस
कोई और है।
बोलिए।
और विटनेस के तौर पर उनका रिलेटिव सुबीर दास ने भी साइन किया है।
As a witness, a relative of Mr. Debobroto Ghosh, namely Shubir Das, has also signed on, namely Shubir Das has also signed on this document.
Was it signed by Subir Das in your presence?
क्या सुबीर दास ने आपके सामने साइन किया था?
हाँ जी, मेरे सामने में साइन किया है।
Yes. The said Mr. Shubir Das put his signature on this document in my presence.
आप कोर्ट को जमा दे रहे हो? Are you tendering? Are you tendering this document before this court? Before my lord. Are you tendering this document in the honorable court, my lord?
क्या आप ये डॉक्यूमेंट टेंडर करना चाहते हैं?
हाँ जी, मैंने ये डॉक्यूमेंट।
Yes.
Exhibit C. Yes, next.
Next. Mr. Bhimraj का what is this document?
ये डॉक्यूमेंट क्या है?
ये मिस्टर देवव्रत घोष ने 16 जनवरी 2021 को 50 रुपए के स्टैम्प पेपर पर मेरे को लिख के दिया कि आपसे जो मैं 1,05,00,000 रुपए लोन ले रखा हूँ, वो लोन आपको 31 जनवरी 2021 के अंदर आपको रिफंड कर दूंगा पूरा, नहीं तो।
On 16 January 2021, Mr. Debobroto Ghosh took a stamp paper of ₹50, and in this paper he wrote down that the loan amounting to ₹1,05,00,000 which he has taken from me, he will pay the loan by 30th January 2021. 31st January 2021.
हाँ, नहीं दे सका तो मेरा बिल्डिंग का सेकंड फ्लोर आपके नाम से कर दूंगा, रजिस्ट्री कर दूंगा आपके नाम से।
Otherwise,
in case he failed to pay the said amount, comma, the first floor of the
second floor
of his house, he said that the second floor of his house is registered the second floor of his house in my name.
Who has signed this document?
डॉक्यूमेंट किसने साइन किया है?
ये मिस्टर देवव्रत घोष ने साइन किया है।
डॉक्यूमेंट was signed by Mr. Debobroto Ghosh.
Was it signed in your presence?
Was it signed on your presence? क्या ये आपके सामने?
हाँ, मेरे सामने में साइन किया
Yes,
उन्होंने।
he put his signature on this document in my presence.
Are you tendering this document?
क्या आप ये डॉक्यूमेंट this document before this honorable court? क्या आप ये डॉक्यूमेंट टेंडर कर रहे हैं?
हाँ, मैं कर रहा हूँ।
Exhibit B, my lord.
Mr. दूसरी बात पूछा, ये बात है। Mr. Bhimraj, did he make the payment to you?
क्या उन्होंने
as per the document?
डॉक्यूमेंट के मुताबिक क्या उन्होंने आपको पेमेंट दिया था?
नहीं, उन्होंने पेमेंट नहीं दिया।
No, he failed to pay me back.
कल से कोई भी डेट बिना पार्टी दोनों रहेगा, कोई डेट नहीं देगा, कोई मेंशनिंग नहीं देगा, दोनों पार्टी रहेगा, मेंशनिंग।
Then what is this document?
फिर ये डॉक्यूमेंट क्या है बताइए?
ये उन्होंने फिर 30 अप्रैल 2021 को उन्होंने जब पेमेंट नहीं किया, 30 अप्रैल 2000 को मेरे को एक चेक दिए।
On 30th April 2021, he gave me a check.
चेक है 1,16,45,000 का,
amounting to ₹1,16,45,000 rupees. 45,000 rupees.
ओरिएंटल बैंक ऑफ कॉमर्स का,
of Oriental Commercial Bank.
What was the check number? Can you tell?
हाँ,
नंबर क्या है आप बता सकते हैं?
039209।
039209 is the check number.
Who has signed this check?
ये चेक किसने साइन किया है?
ये देवव्रत घोष ने साइन किया है।
The check was signed by Mr. Debobroto Ghosh.
What is the name of the bank on which that was drawn?
बैंक का नाम क्या है?
ओरिएंटल बैंक ऑफ
Already there.
टालीगंज सर्कुलर रोड ब्रांच का
तो
ओरिएंटल बैंक ऑफ कॉमर्स
ओरिएंटल बैंक ऑफ कॉमर्स, टालीगंज सर्कुलर रोड ब्रांच, न्यू अलीपुर.
Who has signed this check?
Already you put the question.
Where deposit this check? Where did you deposit this check?
Where? Yes. आपने ये चेक जमा किया था कहाँ?
हाँ, ये मेरे बैंक में HDFC बैंक CR एवेन्यू ब्रांच में मैंने ये जमा किया था.
Yes, I have deposited the check on my bank HDFC branch.
CR एवेन्यू
branch
27 मई 2021 को.
on 27th May 2021. टेंडर হবে?
हो गया.
हाँ, हाँ,
What happened to the check? Did you get the payment?
चेक के साथ क्या हुआ? आपको क्या पेमेंट मिला?
नहीं, चेक का मेरे को पेमेंट नहीं मिला. 29 मई.
No, I didn't get the payment. I didn't get the payment on 29th May.
29 मई 2021 को ये चेक रिफंड आ गया, डिजोनर होकर वापस आ गया मेरे पास.
On 29th May 2021, the check got dishonored and it was returned back to me.
What was the reason for?
चेक डिसऑनर होने का कारण क्या था?
Reason for dishonor of check.
अकाउंट डोरमेट बोल के रीजन है. अकाउंट डोरमेट.
The reason of the dishonorment of the check was account dormant. Dormant. D-O-R-M-A-T.
On which date it returned back to?
Date it was.
It returned back to you.
किस तारीख को ये आपके पास वापस आ गया?
29 मई 2021 को.
On 29th May 2021, the check was returned back to me.
Are you tendering this document?
क्या आप ये डॉक्यूमेंट टेंडर कर रहे हैं?
हाँ, हाँ.
Yes. Exhibit E, my lord.
Are you tendering all these people? Just 3 documents are there. Tell me what are those documents?
यहाँ पर 3 डॉक्यूमेंट है, माय लॉर्ड को बोलिए ये क्या है?
ये चेक है.
The first one is the check.
Second one, deposit slip.
The second one is the deposit slip of the bank.
And the third one?
Third one is return memo from HDFC Bank.
And the
Third one is the check
is
return memo from the HDFC Bank.
Bank. Check return memo.
Exhibit C.
With E, my lord.
E collectively. Yes, next.
Mr. Bhimraj, what happened thereafter?
इसके बाद क्या हुआ?
इसके बाद मैंने उनको तकादा कि क्या बात है, पेमेंट नहीं आ रहा आपका, तो उन्होंने वापस मेरे को एक चेक दिया, पोस्ट डेटेड चेक दिया.
After that, I told them that the check got dishonored and they gave me another check.
Tendering that?
हाँ.
Yes, sir.
What is this document?
ये डॉक्यूमेंट क्या है, माय लॉर्ड को बोलिए.
ये मेरे को उन्होंने फिर वापस एक पोस्ट डेटेड चेक दिया 28 जून 2021 की डेट का.
He gave me another post-dated check date on 28th June 2021.
उसका फिगर सेम था, 1,16,45,000.
The figure of the check was the same as the previous one, 1,16 lakh 45,000.
What was the number of the check?
Check number क्या है?
039210.
039210 is the check number.
And the bank name?
What is the name of the bank?
Oriental Bank of Commerce.
Oriental Bank of Commerce.
टालीगंज सर्कुलर रोड ब्रांच.
Taligon Circular Road branch.
Who has signed this check?
ये चेक किसने साइन किया है?
ये देवव्रत घोष ने साइन किया.
The check was signed by Mr. Debabrata Ghosh.
Are you sure that it has been signed by Debabrata Ghosh?
The check was signed by Mr. Debabrata Ghosh. क्या आप sure है कि ये check?
हाँ हाँ, उन्होंने मेरे सामने में साइन किया है।
Yes, I am sure because he signed on this check in front of me, in presence of mine.
Did you deposit this check?
क्या आपने ये चेक डिपॉजिट किया था?
हाँ, मैंने 29 जून 2021 को मेरा HDFC बैंक CR ब्रांच में जमा किया।
Yes, I have deposited the check on 29 June 2021 in my HDFC Bank CR Avenue branch.
Was this cleared? Was this check cleared?
क्या ये चेक क्लियर हुआ था? आपको पेमेंट मिला था?
नहीं, ये चेक क्लियर नहीं हुआ। ये 1 जुलाई 2021 को ये चेक वापस से रिफंड आ गया।
This check was also not been cleared. On 1st July 2021, this check was also returned to me.
It was returned without payment.
Yes.
It was returned without payment. Answer yes.
Now, have you tendered this check and all these documents?
क्या आप ये चेक और जो साथ में डॉक्यूमेंट्स है ये टेंडर करना चाहते हैं?
हाँ जी।
Yes.
Connectively.
Mr. Bhimraj ka,
One second, sir.
when this check returned back to you, what did you do thereafter?
चेक आपके पास वापस आने के बाद आपने क्या किया?
मैंने मेरे एडवोकेट के पास गया।
I went to my advocate and
हाँ,
went to my advocate, consulted my advocate करो।
उनको पूरा सब बताया जैसे जैसे चेक मेरा रिफंड आया है।
And narrated the whole story about this dishonorment of checks to him and
तब उन्होंने 7 जुलाई 2021 को
then on 7 July 2021
उन्होंने डिमांड नोटिस भेजा।
my advocate sent a demand notice to them
देवव्रत घोष।
to send a demand notice to Mr. Debabrata Ghosh.
Which lawyer went this notice to?
Which lawyer?
Which lawyer? What is the name of the lawyer?
Advocate का नाम क्या है?
मेरा एडवोकेट नाम रतनलाल जी जोशी। रतनलाल जोशी।
Ratanlal Ji Joshi was my advocate. It's the name of my advocate.
Is this the carbon copy of that letter?
क्या ये उस लेटर की कॉपी है?
हाँ हाँ, उसी लेटर की कॉपी है ये।
Yes, this is the photocopy of that letter.
ये लेटर आपके किसके सिग्नेचर है?
Whose signature appear on this letter?
इसमें
signature.
इसमें मेरे सिग्नेचर है।
This letter contains the signature of mine. It contains the signature of mine.
इस लेटर पे किसका सिग्नेचर है? चेक के लिए।
मेरा
इंग्लिश में क्वेश्चन कीजिए सर।
Sorry. Who has signed this letter?
Who has signed this letter?
ओ,
किसने साइन किया है
ये लेटर मेरे एडवोकेट रतनलाल जोशी जी ने साइन किया।
This letter was signed by. Then says this letter was signed by my advocate, namely Mr. Ratanlal Joshi.
Are you aware of this signature?
क्या आप उनके सिग्नेचर को पहचानते हैं?
हाँ, मैंने उनके सिग्नेचर को पहचानता हूँ।
Yes, I know his signature. I am aware of his signature.
नहीं, वो नहीं ले रहा, नहीं ले रहा।
क्या आप ये लेटर टेंडर करना चाहते हैं?
हाँ हाँ, मैंने टेंडर करा।
Exhibit G.
What are these documents? Please tell me.
ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए।
ये स्पीड पोस्ट से जो मैंने मेरे एडवोकेट रतनलाल जोशी जी ने जो भेजे उसका कॉपी है, उसका मतलब जो कोरियर स्पीड पोस्ट का जो स्लिप देता है वो स्लिप है।
This is the slip of the speed post by which the letter was sent to Mr. Debabrata Ghosh by my lawyer, namely Mr. Ratanlal Joshi. Sent to Debabrata Ghosh by Ratanlal Joshi, by my advocate Ratanlal Joshi.
उसके बाद
Yes,
ये-
next.
Yes. My lord, there are other documents.
Let me put the
ये
question.
ट्रैक है, ट्रैक रिपोर्ट है,
And the second document is the track consignment report dated
डेटेड 8 जुलाई 2021 का।
8 July 2021.
इसमें इसमें एड्रेस 10 जुलाई को वो लेटर वापस आ गया, एड्रेस ही एब्सेंट बोल के।
On 10th July 2021, the letter was returned back, giving a note that the addressee was absent. Giving a note that the addressee was not absent.
ये नहीं लिखूं, ऑर्डर हुआ ठीक है।
Sir, it exhibit হবে?
हाँ
अरे टेंडरिंग दिस
हाँ हाँ हाँ।
Each collectively.
Yes, next.
हैं ये नहीं है, ये जाए। Please tell me what is this note? What is it?
ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए।
ये हाई कोर्ट का मतलब काउंसिल इससे हाई कोर्ट का काउंसिलिंग डिपार्टमेंट से कमेटी से है, जो कि वो 11/10 को इशू हुआ है, 11/10/2023 को।
This is a letter from the counseling
It's a non-starter report issued by the
Non-starter
non-starter report.
issued by the mediation and conciliation.
मेडिसिन एंड काउंसिलिंग कमेटी से।
Vote for mediation.
Mediation and conciliation committee. Member secretary, mediation and conciliation committee.
Are you depositing this to the honorable court?
हाँ
Yes.
What is your prayer now? What do you want?
Exhibit G.
क्या आपका प्रेयर क्या है?
मैं चाहता हूँ
आई হবে তো।
हाँ मैं
Your prayer.
मैं
Prayer क्या है?
मैं चाहता हूँ मेरा चेक अमाउंट और जो भी इंटरेस्ट है, जो भी मैं क्लेम किया हूँ विथ इंटरेस्ट, चेक अमाउंट विथ इंटरेस्ट, हाँ वो मेरे को मिलना चाहिए।
I want the claimed amount to be back with the interest.
और क्या चाहते हैं? बोलना
और कुछ चाहते हैं आप?
हाँ
What else
What
do
do you want to say more? Anything more?
What else do you want?
Yes, next.
सर मैं चाहता हूँ जब तक मतलब वो प्रॉपर्टी कोशिश कर रहा है कि बेच के इधर उधर चल जाने का, जब तक उसको सर इमीडिएट क्या
He's trying to sell his property. He is trying to sell his property and go in somewhere else.
तो जल्दी से जल्दी उसको प्रॉपर्टी को सीज किया जाए।
I want to his property to be seized as early as possible.
और इसके अगेंस्ट में जो भी कॉस्ट इंटरेस्ट वेबर जो भी चार्ज रिसीवर जो भी अपॉइंटमेंट करना है, हाँ, तो उसका सभी खर्चा उनसे मिलना चाहिए मेरे को।
And for that
I also pray for the cost of the proceeding.
कॉस्ट इंटरेस्ट एंड फर्दर इंटरेस्ट देयर
I also pray for the cost of the proceeding. Yes. Or next.
रिसीवर अपॉइंटमेंट जो भी लगे सब कुछ मिलना चाहिए।
Nothing more.
नहीं
Yes. ठीक है। Census appearing for the plaintiff witness is present. Examination in chief is concluded. During this examination, how many documents? Exhibit A2? Exhibit A2, Exhibit I, we have marked. Full stop. Evidence of the plaintiff is closed. Any further witness? Any further witness?
This is the only version. I have no further witness.
Last verse. It's closed. Counsel for the plaintiff submit that he will not adduce any further evidence. Further evidence. Evidence on the side of the plaintiff is closed. On the side of the plaintiff is closed. Fixed for argument. List the matter on. List the matter on.
First video इनका नाम
23rd of August 2024 for argument. Yes, next.
Your Lordship, Lordship,
Call that call the list. Oh, that one. Supplementary.
Your Lordship, may I mention one matter? This is a little urgent, if Your Lordship allow me.
Yes. Mr.
My lord, kindly, my lord, takes the plaint, my lord. I am presenting the plaint. My lord, 3 leaves, my lord, I require, my lord. One is a leave under clause 12. My lord, for that, my lord, lordship will kindly straight away come to para 42. Lord, this is a declaration injunction suit challenging a wrongful invocation of a bank guarantee. And my lord, the reason we are seeking clause 12 leave, my lord, the communication of acceptance received at the office of the plaintiff at 3A Loudon Street. Second, the bank guarantees were all issued, my lord. Earlier, my lord, the bank defendant number 1 bank was Allahabad Bank at 17 RN Mukherjee Road. And my lord, after the merger, my lord, with Indian Bank, it is at 14 India Exchange Place. So, my lord, that is the second part of the cause of action within. And the third is, my lord, we have pleaded fraud because, my lord, the 3 grounds on which a challenge to bank guarantee can be made: fraud, special equity, and not in terms of the bank guarantee. So, my lord, fraud was discovered at 3A Loudon Street. So, my lord, this part arose within. And, my lord, we have stated in the second limb, my lord, the portion which has my lord, arisen outside, my lord, the defendant number 2, my lord, is a public sector undertaking in Rajasthan. So, my lord, that is why this is the basis for, my lord, clause 12.
Yes.
And, my lord, order to rule 2, lordship will kindly take, my lord, paragraph 45. My lord, we have a substantial monetary claim in excess of 5 crores. But, my lord, because, my lord, it was served on us yesterday, this has been drafted overnight, my lord, we couldn't gather all the particulars. So, my lord, though, my lord, these are separate cause of actions, because, my lord, my cause of action in the suit is a fraud, while my money claim is my payments due under the agreement. But nonetheless, as a matter of abundant caution, we are seeking order to rule 2, such that, my lord, I can claim monetary relief at a later stage. We have stated that in paragraph 45.
Yes.
And, my lord, the last leave that I require is, my lord, section 12A, dispensation of the 12A, because it's a commercial suit that has been stated in paragraph 44.
Yes. Yes.
My lord, now, my lord,
the plaintiff has filed a suit praying for urgent relief. This also submitted that the plaintiff and the defendants both are within the jurisdiction of this court, but some of the cause of action arose outside of the jurisdiction of
the
this
plaintiff and defendant number 1 is within, D2 is outside.
Yes, plaintiff and the defendant number 1 are within the jurisdiction of this court, and the defendant number 2 is outside of the jurisdiction of the court. The plaintiff further submit that there will be a chance that the plaintiff can claim the monetary relief against the defendant number 2. He further submit that as there is an urgency, and he further submitted that the suit is a commercial nature and there is an urgency, and also prayed for a leave under section 12 capital A of the Commercial Code Act of 2015. Consider the submission made by the counsel for the plaintiff, leave under clause 12 of the latest patent, 1865, order to rule 2 of the CPC, leave under order to rule 2 of the CP3, as well as leave under section 12A of the commercial court is granted. Print is admitted, subject to scrutiny by the
Deeply.
Yes. what
Kindly
is
takes the
application?
injunction application, my lord. My lord, I'll be very short, my lord, because I'm detaining your lordship on a Friday. My lord, the invocation of the bank guarantee, before I say that, my lord, lordship knows, my lord, I have to establish a case of fraud or of special equity, or, my lord, it is not in terms of that. My lord, I establish all the three. My lord, first is, my lord, I'll give in 1 minute the background. My lord, the contract lordship will find, my lord, kindly comes to page 26 of the injunction petition. Page 25.
Yes. 2018.
Yes. Contract is of 13th August 2018, my lord. This is in respect of construction, my lord, of electricity infrastructure, which is, to be precise, 220 kV, my lord, direct transmission lines, my lord, somewhere in Rajasthan, in Jaisalmer. My lord, we were the successful bidders pursuant to a tender. Initially, my lord, a letter of acceptance was given, then a formal agreement was entered into. My lord, to cut a long story short, my lord, there was an initial period, it was extended. Then, my lord, there was some delay. Ultimately, my lord, the work was completed. My lord, the completion certificate, lordship will straight away kindly come to page 442. Volume 4 it should be. Lord, all that I am trying, sorry, volume 3. 442 is in volume 3. All that I am trying to show is, my lord, that there is no, because, my lord, this was a performance guarantee.
Yes.
There is no dispute with regard to the performance for the last 4 years, because, my lord, the work was completed in 2021, and, my lord, they have taken over in 2021.
Yes.
442, lordship will find that completion certificate, my lord, pursuant to GC clause 24, GC is general condition of contract, construction of work so and so, we hereby notify you, complete on the date specified and in accordance with the terms. Lordship will find, my lord, 1, 2, 3, item 3, date of completion, 28,
page
442.
Annexer E, dated 17/12. That is, it is extension.
My lord, kindly takes the injunction petition, my lord. Lordship is looking at the plaint or the injunction.
Injunction. 442 is some other letter. That is a time extension.
May I just have a look, my lord? ये लगी जो this is the plaint, my lord. प्लेन टच प्लेन प्लेन डिपार्टमेंट भूल लिखे दिए छे GA1 प्लेन
देखो उल्टा कर दिया लगता है वॉल्यूम 3 दो वहां से
হ্যাঁ পিটিশনে কেটে দিয়ে ওখানে লিখে দিয়েছে দেখো GA1 টা উল্টো করে দিয়েছি
Yes, 442.
All right, 442.
Yes.
(442) is the completion certificate showing the work is completed on 28th March 2021.
Yes.
And my lord, this letter does not last 2 lines. Obligation to complete execution of facility accordance with the contract obligation during defect liability period. Then my lord, kindly sees the next page. Then in 3 months, the taking over certificate. All other works are done. Taking over certificate 443.
Yes.
Work successfully completed. Yes. Then this is on 11 June 2021. In terms of the contract, the defect liability period is 1 year from, my lord, the date of issuance of the TOC or the taking over certificate. So, my lord, 12th June 2021. So we go to 12th June 2022. 11 June is the date. Lordship will find right at the bottom.
Yes.
And then, my lord, the next page, 444. On February 22, they also release the 10% retention amount for supply and services. which was to be released in TOC, in terms of TOC. 444, Lordship has that, my lord?
10%, yes, contractor returns.
Yes. Then, my lord, from 22, so my lord, in June 2022, the performance security, which was by way of bank guarantee, my lord, I was supposed to get it returned. And, my lord, the contract says, my lord, one more clause, Lordship will kindly have a look. That kindly comes to page 289.
Yes.
Yes, I'm good at it. 289, Lordship has come, my lord?
Yes.
289, in fact, my lord, 288, last line, if Lordship sees. These are amendments to the general conditions of contract. Performance security shall not be reduced on the date of operational acceptance and shall be of value date. The security shall become, at 289, my lord, I am reading, security shall become null and void or shall be reduced pro rata to contract price of a part facility so and so after 540 days of completion or 365 days after operational acceptance, whichever is first provided. 365 days over in June 2022, and Millard security deposit has become null and void. So, Millard, from June 2022, they caused Millard. Now, Millard, one more letter, they ask us, Millard, to keep the bank guarantee valid. And the reason, therefore, is Lordship will find, kindly see the last extension letter at page 452. (452) should be in volume 4.
Be a print. Application.
Petition 452. Volume 4 petition.
(452).
Yes. 452.
Yes.
This is as on 2023. Lordship will find it is to inform you validity of the noted bank guarantee is expiring on the date mentioned. My lord, it was valid. Lordship will find up to, my lord, 31st March 2023. Now, you are therefore requested to extend the validity of the bank guarantee up to the period mentioned on so and so stamp paper so and so in the name of chief engineer so and so, directly addressed, failing which the bank guarantee shall stand operated without giving you any further notice. So, in spite of that becoming void, they, my lord, force us to keep it extended, that if we don't extend it, they will just immediately encash it. And my lord,
if you're June 2023, it is a March.
Yes. March, my lord, 2023, I am forced to extend. Then, my lord, kindly see the last extension, which is at 454. Same language, my lord, I extend it. My lord, they ask us to extend it till 2025. I extend it till December 2024. Now, my lord, in the meantime, from 21 to 2024, there is not a single demand of any non-compliance. On the contrary, my lord, they have deducted 27 lakhs and odd from my pending bills, which I am to receive payment for liquidated damages. So whatever that has been done, then, my lord, all of a sudden, they invoke it.
No, if it is completed, 365 days is completed in June 2023. So why you agreed for the extension further?
My lord, not agreed on extension. If I don't, and that is why, my lord, I'll show the relief. Threefold declaration has been sought for. Declaration that the extension is by coercion, because, my lord, Lordship will find it is not that, my lord, the contract is pending. You extend it. If you don't extend it, we will encash it. And the reason why we are asking is the extension letter. My lord, kindly take any of the letter. Kindly take the last extension also.
Threatening.
Second line, Lordship will see. Further extension is required as case under decision. Their administration is taking a decision whether to close the contract or not.
It is informed validity and below is expiring and mention it. Extensions required as a case under discussion. Yes.
Case under decision. And if you don't extend it, it will stand operated. So,
Yes.
my lord, I extend it and then kindly come to the immediate cause of action 495, the last document.
495.
Yes.
Yes.
On the subject cited above with reference to performance security executed by you of the undersigned valid up to 30th June with claim period up to 30th June 25, it is stated party have not fulfilled its contractual obligation. I therefore.
So this is the date?
This is, my lord, on 30
July.
31st, 30th July, my lord, we have received it yesterday.
So this is the impugned letter.
This is the impugned letter. My lord, this is digitally signed. Lordship will find, my lord.
Yes, that is
at the bottom. It is digitally signed. 30th of July.
So prior to this, there is no demand.
There is no demand, nothing. From 2021. Not a single demand. Lordship will not find, my lord, a single allegation that I have not. And defect liability period has also got. My lord, the last document which they have sent is at page 445. As I was telling your Lordship, my lord, the LD. 445, Lordship will have a look. This also we are disputing, but my lord, be that as it may, my lord, my pending bills are in excess of 5 crores. Even if this is taken to be correct, it's only 27 lakhs. Kindly see.
For that, they're invoking 470.
No, they're not. This is also not for LD, because if it is for LD also, it is 27 lakhs, my lord. They can't invoke 2 crore 44. Kindly see LD. But, my lord, they are holding, my lord, bills worth more than 5 crores.
So what you want to 445?
445 is, my lord, the last correspondence, which is, my lord, of 2023. Lordship will find calculation of delay, total delay of 685 days. Then, my lord, in serial 1, Lordship will find 652 days on the part of RBPM, that is without levy of LD.
Where from you are reading? It's a plaint again, yeah.
445. I'm sorry.
Which quarter?
440.
Yeah. उसको हटाइए. Yes, 445.
445.
652 days on the part
without,
of the...
without, that is, my lord, the
Without
defense number
LD.
2. Without levy of LD, 33 days delay on part of the firm with LD of 0.2%, 5%
of the total.
So and so, and my lord, they have calculated it at the next page. Lordship will find 27 lakhs and odd.
Yes.
And my lord, on the face of it, my lord, Lordship has already marked, my lord, that document, my lord. Kindly also take into consideration page 441.
441.
Yes.
Yes.
441, my lord. 10% retention, my lord, for supply was also directed to be released in April 21. And this money, my lord, I have already got. 441. I made a mistake, my lord. 444, which I showed your lordship. That, my lord, they have already directed to release it, but, my lord, I am yet to get it.
No, as per 441, 10% is released.
Yes.
No, 10% retention.
Retention, my lord.
Pro rata.
My lord, there are two 10%. 441 is retention amount for supply and service upon issuance of completion certificate.
Correct.
And, my lord, 444 is 10% retention upon issuance of operational certificate, that is the TOC facilities. Kindly see.
Oh, yes.
So, my lord, both have been directed to be released. But I have already received the money of 441. I have not yet received the money of 442.
And they are going to encash another.
And they are going to encash another, my lord, 10%, which is, my lord, 2 crore 44.
442, 441.
441 and 444.
Correct.
There are two released letters.
Correct.
One is upon completion certificate.
Correct.
They directed to be released. I have received it.
Correct.
444 is upon operational certificate, my lord, takeover certificate.
Correct.
That also, my lord, they have directed for release, but I am yet to receive the money.
442 are not received.
444 I have not received.
That's you are not received.
441 I have received. And my lord, my pending bills of 5 crores and odd, my lord, that is also there. While order to rule to lordship has seen, I have a claim of outstanding of 5 crores and odd.
Yes.
So, my lord, when I challenge it, my lord, 3 paragraphs I show your lordship on the petition. My first point is that it cannot be a performance issue because performance has been admitted by defendant number 2 itself in issuing both the certificates. Acceptance, my lord, was in 2 stages. That is completion certificate, takeover certificate. Number 1, no performance issues can be raised. Number 2, in terms of the contract, the security deposit becomes null and void after expiry of 365 days from the takeover certificate. So once you issue a takeover certificate in June 21, defect liability period ends in June 2022. Well, that clause I showed your lordship at page 289.
But this completion certificate 440, that is issued on 28th March.
Completion certificate on 28th March. That is the first requirement. Takeover certificate 11th June. That is at page 443.
Yes, 443. But in 440, page 440, last paragraph, the letter does not relieve you for the obligations of the complete the execution of the facilities in accordance with the contract, not for your obligation during the defect liability period.
Correct.
Okay, 1 year passed. Yes.
So, my lord, after March, my lord, in June, whatever obligations were there, June takeover certificate. This is the final certificate. My lord, they take over the plant from us.
Okay.
So this is there. Defect liability period is 1 year therefrom.
Correct.
And that is why, my lord, I showed your lordship, my lord, the clause at page 289. The security deposit becomes null and void. My lord, it is 540 days from completion of facilities or 365 days from takeover certificate or operational acceptance.
Correct.
Both are over, whichever way lordships look at it. And my lord, in this interregnum period from 2021 right up to 2024, there is not a single letter or demand or any allegation of any breach or any work not being done. Lordship can take it from.
So no demand is there.
No demand is there. And the only levy that they have done in 2023 is liquidated damages, that too for only 27 lakhs. Assuming they are entitled to, it is much more than our outstanding. It is they are already holding the rest of them.
What has happened to that demand of 27 lakh?
27 lakhs, my lord, I get 5 crores. So if they adjust it, my lord, from 5 crores 17, they will adjust 27 lakhs.
Minus.
Because, my lord, my final bills are pending. Because they did not have final closure in their accounts, they forced me to keep the bank guarantees extended.
Yes.
So, my lord, now kindly comes to the injunction application once. 2 paragraphs I show your lordship. We have given the particulars of fraud and coercion. My lord, there are 2 parts. I have been coerced to keep the bank guarantee extended after June 2022. I have shown your lordship the reason. Not because there is any performance issue. Because, my lord, they are to take a decision on the case.
Yes.
And if I don't extend it, they would invoke it as a matter of course. That is the invocation letter.
Yes.
And when they really invoke it, there is no demand preceding that. They just say, I have not performed my obligation. Not a single letter in 2021, after 2021 June, right up to the invocation, my lord, in 2024. Not a single letter. Now, in this background, kindly comes to the petition. 2 paragraphs I show your lordship. My lord will kindly come to paragraph 32. Well, at paragraph 32 in the sub-paragraphs, we have given the particulars of fraud and coercion. I just show your lordship 3 sub-paragraphs. Respondent 2 was aware that security being the bank guarantee had become void on and from 11th June after the defect liability period was over. Respondent 2, while calling upon the petitioner to keep the performance guarantee extended even after issuance of takeover certificate and completion certificate, always intended to unjustly enrich itself by not acting in terms of the contract. Then, my lord, kindly come to clause D. The respondent number 1, having been made aware of the fraud, my lord, bank, I have to only show that I have written a letter to the bank. I have written it yesterday itself that this is not, there are no performance issue. It's a fraud. You are being made aware of the fraud. So, my lord, that is the only pleading I have given, that respondent 1 has been made aware of the fraud. And then, my lord, the last one, F, respondent 2, by threatening to encash the bank guarantee which had already become void in the event the same was not extended post June 2022, was threatening to detain or appropriate the property of the petitioner to prejudice of the petitioner with the intention of causing the petitioner to extend the bank guarantee. Well, this is the particulars of coercion. And well, the last one is of fraud. Well, that is in H, I, and J. Actively concealed fact that the bank guarantee had become null and void in spite of having knowledge and belief, otherwise acted in a manner fitted to deceive, and lastly, my lord, had a duty to disclose. HIJ.
Yes.
And my lord, we have also pleaded special equity. And my lord, the reliefs that we have claimed in the suit, I'll just show your lordship. Lordship will find that at para 42. My lord, 2 are declaratory reliefs. One is that all the extensions which were made, my lord, are vitiated by coercion and fraud, because, my lord, after June 22, I had no obligation to extend it, but because of the threat, my lord, we had to do it. B is declaration that the bank guarantee invocation is, my lord, vitiated by coercion and fraud and is liable to be adjudged null and void, as the bank guarantee has become null and void with effect from 11 June 2022. C is a delivery up and cancellation of the bank guarantee. D is perpetual injunction. And, my lord, I am seeking temporary injunction, my lord, in aid of the perpetual injunction. Now kindly come to page 21. My lord, injunction restraining the respondents, my lord, from giving any effect or further effect of 31st July. And, my lord, prayer B is restraining respondent 1, its men, servants, and agents are assigned from releasing and or paying any part or portion of this. My lord, we have broken up the perpetual injunction into 2. The first one is vis-a-vis that B and C. We have broken it up. Prayer B is, my lord, against the bank, and prayer C is against respondent number 2.
So, for the ad interim, A is enough.
For the ad interim, A
is enough. Then, with regard to the other,
very well, very well. Ad interim, my lord, A is it's a omnibus prayer.
It's covered.
Respondents, it's covered. Not to give further.
Any further?
That's it. There are other clauses, and I don't want to waste time, my lord. I must be candid, my lord. Lest, my lord, later it says it is suppressed. It has been stated in the plain. There was a dispute resolution clause that was in 2 stages: dispute board and thereafter arbitration. But dispute board was never formed, and because it was a conditional clause, we cannot refer it to arbitration. All the facts have been stated in the plaint and in the petition.
I will go.
My lord, after extreme urgency, my lord, I am bothering your lordship, my lord. My lord, my item number 14, which was moved ex parte, my lord, by Mr. Bachawat. My lord, I don't know, I was not there. My lord, there was a suit filed by the defendant, which had come up before the Delhi High Court against the plaintiff. There, my lord, they had appeared. And without and suppressing that there was a suit filed out here, they have taken time. Well, today out here, I don't know whether it was submitted that the suit has been filed in Delhi High Court by the defendant.
They have given the details.
And,
and it was moved. I'm from Delhi, my lord. I'm so sorry, my lord. My lord, I was
that, my lord.
We served them the copy of the Delhi suit on 31st of July. I'm so sorry, my lord, to mention and intervene in between. Now the position today, my lord, we were in the process of filing a KVIT in Calcutta also, but both the parties filed KVITs in Delhi High Court. And accordingly, we served them the advance copy on 31st of July. The matter came up today, my lord, which is posted on 9. Now today, my lord, I learned, my lord, they have approached the Calcutta High Court, my lord, for the interim relief, where parties are already contesting the matters before the Trademark Office. And there is an agreement of co-ownership of this trademark, my lord, that came in 2023. And these particular plaintiff in Calcutta High Court are the ex-partners. What my humble submission today, the main company has already entered into, my lord, the co-ownership agreement with me. I don't know, my lord, all these things were there. The legal notices were exchanged, my lord, 2 months back. And we filed a suit here. Now, probably, my lord, I know, my lord, I was not on KVT in Calcutta High Court, but when both the parties filed a KVT in Delhi High Court, my lord, I also filed, they also filed. And we served them our advance copy on 31st of July. So, my lord, my submission was because any ex parte order, I know, my lord has already heard the matter. At this point of time, my lord, I should not have mentioned this, but I want to bring certain facts. I can come on Monday. My humble submission today, I can be present before my lord on Monday. My lord, or my lord may direct. That's the position, my lord. But my lord, I just need 2 minutes, my lord, on the merits to be heard. And thereafter, I will leave to the honorable court, my lord, to pass any orders. I can come, my lord, I can be there 10:30 sharp Monday morning, my lord. I can only say this. Because we pressed today, my lord, even these other counsel senior was present. They just took time and the matter went on 9th. That was the position, my lord. And when the parties are exchanged with the legal notices, this is my humble submission, my lord. I'm so sorry, my lord, to bothering. But my lord can call me on Monday morning. We can inform the other side. We can both be present, my lord, 10:30 early morning, my lord, to the and we can submit this. And in case my lord finds that, okay, I don't have any case at all, then my lord can always issue a interim order against me. But I just wanted to make a submission. I just want to make 2-minute submissions. I want to show 3-4 documents in their presence, which are admitted documents. There's a co-ownership agreement. We have paid them 10 lakh rupees. That agreement is there. And they have admitted co-ownership rights with that. That's the position. And behind the back, my lord, going and my lord, getting my lord some order, praying for that. That is not very good, my lord, because 31st of July, we gave them the advance copy of the Delhi suit. And probably, my lord, this Calcutta suit, probably they have filed after 31st of July. So my suit, which was filed in Delhi High Court, my lord, that was, my lord, 31st of July evening. And even yesterday night, I received a call from Khaitan and Company that is the matter going to be listed tomorrow in Delhi High Court. I said, yes, it is going to be listed. But they never informed me that, okay, Calcutta High Court's matter is also listed tomorrow. That was the position, my lord. So my humble submission, my lord, may just see I'm entirely in the hands of my lord.
Okay. To be mentioned notice. Okay, you said the notice.
My lord, we'll issue a notice upon the other side.
Keep as a to be mentioned.
Lordship, I'm grateful to your lordship.
My lord.